Also heard Mr. P.P. Gogoi, who submits that who prays for another date for producing the case diary. Prayer is allowed. Let this case be listed again on
11-12.
11. You are on interim.
Interim.
The interim order shall continue till next day.
It's a regular bail application filed yesterday, my lord. It is similar to that case which you also heard on 15, when the matter relating to Humani Rava case. You also fixed on, my lord, on 28th of this month for delivery for that. I think the same matter, my lord. It's also languishing for 180 days. I also include certain order for the anesthesia. When the time is sought for by the CBI.
Now, what do you want?
On Monday, my lord. I think a similar matter, arising out of the same FIR, and a record is already produced by the CBI.
Motion.
Motion.
Order item 44. The petitioner has already surrendered before the learner PTM test court on 31st of October.
Heard Miss. What is your name?
Miss P. Bora.
Heard Miss P. Bora, who submits that the petitioner has already surrendered before the Senate CM stage Sonitpur, and in view of the surrender, the anticipatory bail has become effective. This anticipatory bail application is accordingly dismissed on is disposed of on becoming effective.
Highly object.
Proceed by victim mention item number 24. The conducting something with the I have already out of 3. Item number 24. The comment taken after 3 weeks.
Heard Mr.
D. Goswami.
B.
D. Goswami.
D. Goswami submits that who prays for an adjournment on the ground that the conducting counsel Mr. A.K. Sahewala is out. Considering the grounds mentioned by the London Council, the prayer is allowed. Let this matter be listed again after 3.
Let me pick for 11th of
11. Let this matter be listed again after 11th of
For listing of the criminal appeal matter on 23/11/2023.
what record?
He is a working as a constable mallet in CRPF and the appeal is also pending. That's the
No, for listing of appeal, you have to approach registry, make prayer. This is a fresh appeal,
no matter
pending appeal,
for pending appeal, not for hearing matter.
of which year?
10 years. Single pen.
No.
When
Is to register.
you make prayer before registry, they will do the
application.
Daily list motion BA item number 1.
This case, the petitioner is a driver by professional notice. On the date of occurrence, one passenger Priyanka Das and hired his vehicle, and some Indian bank currency was recovered from the Priyanka Das and from his bag lot. So subsequently, Lordship as being the driver, and he is in custody about 40 days. So Lordship and
case very hard Mr. of that counter go the petition. The result of the case diary would be necessary for consideration of snap bill application. Hence, call for the case diary fixing
4/12.
4/12.
This month from Agra, very near, and 40 days already in custody.
30th May.
30/11. Okay.
Item number 2.
Made to Lordship. The under section 439, chapter 10 offense under 120 PN, a petitioner behind the bar since 30 days. FIR in page
We are calling for the case. Yes. Third, Mr. What is your name?
J.M.
J.M. Sulaiman, Senate Counsel for Petitioner, also heard Mr. B.B. Gupta, Petitioner. Perusal of the case diary would be necessary for it's called for the case. 16,
412.
412. Okay.
412.
Item number
May it's been a case of illegal arrest. My lord will kindly note down some of the dates, my lord. An FIR has been lodged as cyber PS, my lord, on 14/9/2023. On 15/9/2023, my lord, this accused person was arrested in police station, been produced on 16/9. On 16/9, one of the girl wherein there is allegation of regard to cybercrime being committed, the deceased person, she was also picked up by police, but she was not arrested. Bond has been taken and she's been released. On 16/9, she committed suicide when I was in police custody. And there is no suicide note, nothing. On 16/9, a ZD entry has been made. On 24/9, a case has been registered, my lord. I have been in police custody in particular cyber case all along. Never disclosed about the pendency of this case and been shown arrest in connection with it. I am taking your lordship to the affair. That is at page, my lord, 8. This is the ZD entry, my lord. Been lost by police officer only. Under 306. And it has been stated, my lord, with regard to that cyber crime case. And my name also appeared, my lord, in the last line, my lord. So working in establishment at the instigation of the above two accused persons to gain more profit by thinking the state establishment as legal. Although the disease was engaged in the state institution and knowing about the arrest of so-and-so in cyber fraud case so-and-so, and under
Now,
apprehension of...
what allegation is against you that you instigated her to commit?
Yes. A
That is-
person behind the bar can instigate, my lord. That will be a new law. We'll kindly come to now forwarding report, my lord. At
No,
page,
when that instigation occurred?
God knows, man.
No, since when you are in
15/9. My lord will kindly
when
come
the
to page
girl
17.
when the girl died,
16/9.
the instigation could have been done.
My lord, instigation for with all respect, I will submit to that, my lord. We'll kindly see, my lord, at page 14. That is the forwarding report in connection with, my lord, this particular case, my lord. Now, I have been arrested and on 30/10/2023, man.
When were you arrested?
30/10/2023.
Shown it.
Shown it.
And since when you are in custody?
Since then, my lord.
No, you are arrested
15/9. 15/9.
since
My- 15/9.
and in this case
And my lord will kindly come to now. This case, my lord,
30/10.
page 17, my lord, will kindly come. With regard to the cyber PS case number, I have been in custody for 15/9/2023 at 7:30 p.m. Now, what is the offense that has been registered? My lord, 306, abatement to suicide. Now, for abatement of suicide, my lord, the three ingredients has to be there. With regard to 107 of the IPC, that I have to, my lord, instigate in commission of the crime. I have to aid in the commission of suicide, or I engages myself in the commission of the suicide. These three elements has to be present.
Let us verify.
My lord, here is a case wherein, my lord, the disclosure with regard to, my lord, the pendency of this case itself is not been disclosed before the lower court below in
No,
cyber period.
your case is that since you are in custody since 15/9,
Yes.
you could not have instigated the offense
Yes.
which occurred on 16,
Yes, my lord.
one day after the.
My lord will kindly appreciate the contents of section 306, my lord.
Yes, Lordship, this is from Chanmari.
No, may I submit, my lord? May I submit? Because it's a illegal arrest. Every moment is every minute is been, my lord, amounts to illegal, my lord. 306, my lord. If any person commits suicide, whoever abets the commission of such suicide, and 107, my lord, will kindly come. Abatement that has been defined, my lord, 107.
No, we have to peruse the case to see whether the instigation was prior to 15/9, prior to date of your arrest.
Well, there is no right declaration.
Let us see the case then.
My-
Let us see the under what are the circumstances, why police is saying that.
Let it be tomorrow, my lord. Tomorrow is a working day. This is summary only. Because my lord will kindly see.
They have to PPI the
Another
diary.
regard to
matter.
cyber crime, my lord, all accused person has been granted bail. Repeated. Now,
You, in cybercrime case, you have been granted bail,
my lord, all accused person, and my lord will kindly see.
but we are not.
Concerned with that. My lord, what I am on, prima facie, my lord, with regard to 306, there has to be some element in the affair itself. A single person, my lord, wherein, my lord, the IO who has lost the affair, my lord, can you see? A police officer. A GD entry has been there with regard to suicide, and he lost an affair on 24/9. And regarding the pendency of this case, my lord, that is Sheikh Abdullah's case, my lord, will kindly see. Nothing has been disclosed with regard to this particular case. Pendency of this case. On 30/10, when I have been arrested, they referred to cyber case, my lord. In the cyber case, this case was never been referred to. Pendency of this case, which has been registered on 16/9, whereas I am arrested from 15/9. On these particular facts, my lord, this I rely on a judgment, my lord, which is, my lord,
Not today.
not today.
Let
it be tomorrow.
When can it be?
Tomorrow, my lord, Salmari police station.
Tomorrow, my lord,
I
I
don't-
will not follow his direction. I'm
No.
a PP. I will follow
No, when can
direction.
you? When can you
Uh,
produce? The,
24, my lord. 24.
My lord, that will be, my lord, too much. Today is 17, my.
because unless case diary arrives tomorrow, it will be.
It will be in Salmari police station, my. If the court directs, why not they have to produce it, my lord? Because my plea is very simple, my lord. Not a regular bail, my lord. I would have appreciated him. I am talking about illegal arrest. That when you arrest a person subsequently, then when you forward the particular person with regard to previous, my lord, pending
That has
cases, you
to
have to
be-
declare.
That
That has not been done. And 306, my lord,
bring it on Monday.
Yes.
Monday.
Yes.
Let it be on. Well, what kind of language is this, my lord? That I will not dictate, my lord. We are making a prayer before the court. Let us be humble to the court, my lord.
Heard Mr. A.K. Punya, running counsel for the petition. Also heard Mr. B.B. Gogoi, running additional purpose. This application under section 439 of the Code of Criminal Procedure has been filed by the petitioner Rajen Sidana, alias Rajen Sidana, alias Ranjan Sidana, alias Ranjan, who has been detained behind the bar since 31/10/2023 in connection with Chanmari PS case number 353/23. Learned counsel for the petitioner submits that the petitioner was earlier arrested in connection with which case?
Cyber PS
Cyber
case
PS case number 8
of 2020
of 2023
on 15/9.
on 15/9/2023. And though the FIR in the instant case has been filed by a police officer, the fact of his earlier detention has not
Yes.
been mentioned in
Yeah.
said FIR. Then counsel for the petitioner also submits that this is a case of illegal detention. On the other hand, learned additional public prosecutor submits that considering the nature of allegations leveled against the petitioner in the FIR, perusal and the nature of offense involved in this case, perusal of the case diary would be necessary for consideration of the instant bail application. So hence call for the case as fixing,
2020.
fixing 2011,
11.
23 for case.
But item number 5, same one. Same FIR, my lord, another accused person, 2 were arrested, my lord. Same order.
He was also earlier arrested,
Yes, same thing.
same order, name
Same.
of the accused.
Name would be different. Same police. I'm authorized.
Item number
May it please the lordship. It is a daily petition, file under section 449. The accused was arrested, petitioner was arrested on 17/10, my lord. And as on today, he has been behind the bars for the last 31 days. Lordship, may kindly see the FIR.
Fake currency.
Fake consumer.
Let us call for the
First of
case.
all, my lord, he is not a named accused in this case. His name was not mentioned in the FIR. First registered in the month of May. My lord. And the petitioner
Since when you are in custody?
since 17/10, my lord. 17/10, lordship, may
Mm.
kindly see the forwarding report in page 11, my lord. 5 months back, the FIR was registered.
No, whether before moving this court, have you approached any other court?
No.
For bail?
No.
Your bail application has not
Not
been
rejected.
rejected.
Not rejected. With the past rejected.
We have to go through the case.
But my humble submission is that he was merely a certain suspicion.
Let us,
Nothing has been recovered.
let us see.
But forwarding says something like that.
Only
Heard Mr.
yes, no,
S. Gogoi, learned counsel for the petitioner. Also heard Mr. P. B. Gogoi, the petitioner. Considering the nature of offense involved in this case, perusal of the case that is felt necessary for consideration of the instant bail application. Hence call for the case like fixing when case
1st of December,
first.
1 month case.
the Puria, the rest 90 days, okay.
Okay.
And
So let me know.
About 439 applications. So lordship will kindly FIR page 10. This is the translated copy, my lord. The original is
Since when you are in custody?
my lord since 6/11. My lord, out and out false FIR. So lordship, I think is
Is there
clear
a-
FIR.
Uh,
Because
Let us keep the case. Heard Mr. K. Mohammed, that is counsel for the case. Also heard Mr. K. Begum, and a petition call for the case like fixing
Lordship 29, Lordship 29/11.
29/11 for
my lord, can it be a
little late.
earlier?
Then Lordship 28, 28.
20. Keep your
Pleasure lordship. 439 application matter. FIR at page 8 matter. Basically, the allegation is under section 498A matter. But section
498,
326 and 307
07
is
are
there.
also there. So we have
CD Lord.
Protect may be given, but otherwise I am 30 days behind the mark.
heard
28,
Mr.
Lordship,
A.K.
28/11.
Learned counsel for the petition. Also heard A. Begum, that the petition for call for fixing 28/11.
28/11.
Obliged.
For motion item number 8.
In this matter, your paper, the petitioner was heard substantially. He produced good from the court after the order passed by the court. Matter pertains to Borthakur was there. It was supposed to on the last day of the case.
Parted matter, Lordship. Appropriate bench.
No, this is
No, it is parted by the,
this bench.
Or this bench.
This bench.
Oh,
what was the matter? I forgot.
Yes, this matter pertains to one order.
Where is the impugn order?
Document only come to page 27.
Whether the case diary has arrived.
Lordship, we don't have the file, the motion, Lordship, so
Motion is being heard from our side. We heard in prospect directed
Where is the impugn order?
case 27. Case present extension was paid. It was granted without the provision have to be followed. The issues must be present before
yeah.
the honorable court.
Yeah.
So I will have to extension grounds. Those grounds have to be appreciated, not being appreciated, or given individual remark by the public court.
So,
That
so
is our
that
case.
perusal of record would be necessary.
LCR may be called for, Lordship. Notice,
Because
notice may be issued, Lordship.
and also the question is that because it's started at the end.
You are behind the bar.
I think more than
But
from
that
25th of April.
That
and then
bail is a different matter. We are not concerned with bail. We are concerned whether the extension order
Yes,
was
it was
legal or
not in a
illegal.
proper manner. That was a
So,
argument.
Lordship, actually, we don't have the petition copy right now.
Because
So
the assurance was given by Mr. Bhattacharya.
no, actually, on last
keyboard.
occasion,
Keyboard.
perusal of the case diary would be necessary.
That is,
Yes,
Lordship,
that is
And
the-
on last occasion, there was a submission by an additional public prosecutor that case diary is pending before some another.
the Lordship, after sometimes I will get the instruction from him, Lordship, whether,
Because
because
if
CD,
we can peruse the case diary,
Oh,
it can be disposed of in the motion statement.
Lordship, actually, Lordship, learned friend is absent, Lordship, Keyboard Thakur, he is absent, so
And also
Or-
my submission was hard and also
so
that is
let him
closed
be
also.
there, Lordship.
In the order passed by the Honorable Court on last occasion.
Or we can do one thing. We will give another date for case diary.
diary.
We admit this case and let this matter come up in admission for
Maybe difficult. So he is behind the
In
bar.
a-
Because
in-
whether the order of this Honorable Court, he may not get the bail because in a
Oh.
similar incident that this Honorable Court has appreciated our argument and quashed the order of action.
no, but for that case diary would be required.
Every case is different. That is it. Being admitted.
Third, miss, when case diary would be,
Lordship,
That is court.
short date due, 24, Lordship,
22.
22 November, Lordship, 22/11.
It will be disposed of
in the motion statement.
because the order was there. Order we are relying.
Heard Mr. R.P. Hazarika, learned counsel for the petitioner, also heard Ms. A. Begum, learned additional public prosecutor, who submits that though
Is that yes?
this case was fixed today for production of case diary, however, same has not arrived and prays for some more time to for producing the case diary. If
Okay,
there is
Lordship.
allowed, let this case be listed again on
22/11.
22/11 for case diary.
And the prayer is there. I can remember 43. In which the Honorable Court has asked, just like AB, and the bail was rejected. On the ground that the other city was being reduced by the Honorable Court, and what ground they need application, subsequent application will be allowed. But for some time, one judgment is
43,
there.
item number
43,
in-
43 on 22nd.
There is CD is there, Lordship. Yes, there is
in
received.
43, heard
CDB
Mr.
retained.
R.P. Hazarika, learned counsel for the petitioner, who prays for some more, who prays for an adjournment on the ground that he needs some time to prepare for hearing.
22/11.
22.
On the other hand, Ms. A. Begum, learned additional public prosecutor, submits that case diary which was called for has arrived.
Arrived.
The prayer is allowed. The case diary may be retained till next date.
Yeah.
Let this case be listed again on
22/11.
And April, April of April.
The division against order of maintenance, madam. While this order, madam, an amount of 15,000 has been actually be paid as maintenance. 5,000 for the child and 10,000 for the wife. At page 27, lot will find it.
We're issuing notice.
Yes, madam. One. At page 31, there is an affidavit of 31. Okay. As an interim maintenance, madam, he has been paying 7,000 in the suit, madam, 125 proceedings. There was an interim maintenance order, and accordingly, he has been paying 7,000. Now it has been disposed of, saying that 15,000 is required to be paid. So it is a bit on a higher part for the part of the petitioner, madam, to pay. Petitioner is able to pay amount of 10,000 till disposal, madam. There are discrepancies in the.
No, you are making a prayer for interim.
Yes.
That we will hear after service of notice. We are issuing notice
My.
after service of notice. If the-
Madam, it cannot be after receipt of LCR. Because, in this cases, madam, the respondent will be.
No, if they don't appear, we will only ensure that the notice is up.
Yes.
Even if she does not appear, we may pass. Third, Mr.
I'm PK Munir. My name is not reflected in the call.
Third, Mr. P.K.
Munir.
Munir, learned counsel for the petition. This application under section 397/401 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Shri Kapil Dev Begu, alias Kapil Dev Begu, impugning the order dated 5/7/2023, passed by learned Subdivisional Judicial Magistrate Mufassal, within bracket M, Jonai, in miss case number 1/2022, whereby the petitioner has been directed to pay a maintenance allowance of rupees 5,000 per month to his minor child, and rupees 10,000 per month to the respondent. Issue notice to the respondent. The petitioner shall take steps for issuing notice on the respondent by registered post with ID within 3 days from date of this order, returnable. You want a fixed date?
Probably, if my lord.
Returnable after 3 weeks. The prayer for interim relief would be considered only after service of notice. Also call for this case has been finally disposed of. Call for the case record of miss case number 1/2022 from the Court of Climate SDM. Let this case be listed after 3.
Well, can it be on December 20th or 21st? Maybe 50 over by then. December 20th.
20th
of December.
Let this case be listed again on 20th of.
Item number 10.
Matter may be taken up at some time, my senior counsel, he also will appear on the in another point.
What is the
After
matter?
My lord, this is a quashing of FIR, my lord. Or moreover, my lord, the case there is not available. So may I pray, my lord?
Let us call for the case date.
An informant is also present, my lord, and he also desired to file an objection, my lord.
Today is fixed for consideration of interim pair.
No,
Other two of the case in the quarter judgment on my lord.
I appeal for the informant in this case, my lord. We have received certain documents, my lord. We want to bring you to record by filing an affidavit. Lot of development has taken place. So we'll file an affidavit, my lord. My lord has to go for a
No,
case.
their prayer is that they want this matter to be taken up after.
But I have to file an affidavit. That's what I am praying before now. And I think case diary is, I don't know whether case diary is not.
Otherwise, even for considering the interim prayer, case diary would be required.
That's what I am saying. Whatever maybe case diary is required.
So let
Now
the,
forget I am an informant, my lord. Your lordship has to look into the case diary. A date may be given, my lord. I also come up with an affidavit. There will be no grievance from any side.
Mr.
H.A.
H.A. Ahmed, learned counsel for the also at Mr. M. Kokan, learned additional, learned public prosecutor, who submits that the case diary which was called for has not arrived in place for some more time for fixing it. On the other hand, Mr. D. Das, learned senior counsel appearing for the informant, assisted by
Either.
Mr. Aidas, submits that the informant desires to file an affidavit
Yes.
to opposing the
Yes.
affidavit in
Yeah.
opposition. Considering the submissions made by learned counsel for the parties, let this case be listed when you can.
My lord, after 2 weeks, in meantime, they have also filed their
I will
affidavit.
also file it.
They have an interim period.
I know, an interim period can be, my lord, the idea behind when the matter, either the matter will be taken endeavor to dispose of the entire matter or will consider for interim. As we file the affidavit and my learned friend, entire matter can be disposed
And
of.
moreover, my lord, is also in interim. My
Interim is there in interim.
Is interim.
That's the whole issue.
He's on interim.
Interim.
Yes,
Interim.
they went
Then
before
what
the,
interim?
but that's for the.
Interim bail, regarding bail.
I'll tell you lordship what has happened. Interim, first bail application AB was moved.
Okay.
The view of the court while moving the AB was that from the contents of the FIR, I think is not a case, interim bail should be granted. So the date was given. Now on that date, they came up before because said, no, we want to withdraw this case. They
Okay.
withdraw.
Anticipated.
Withdraw. They went to the learned sessions court. And these things are not being mentioned on the basis of another co-accused, which was granted in interim bail. In an anticipated bail, bail was granted. Interim bail was granted by the learned trial court. And the learned trial. Then the person who is co-accused who got an interim bail, I appeared and my learned friend also appeared. Then his interim bail was rejected. Only because of his name. He projected himself as this, what is it? Nilam maybe, but Nilam maybe
Kashyap.
allies Kashyap. So on this ground, he rejected. So
Okay.
there is bona fide of
Okay.
this.
Otherwise, in this case, we are concerned only with the quashing.
No, now, my lord,
Yes.
there are two ways. One is that whether your lordship interim or whether there is a protection already. So let it come, my lord, after.
Let the matter be listed again on 5/12.
No, 5 is a bit of difficulty. I'll be honest.
Another.
Thereafter, my any date. Which is
8.
8, my.
8.
Yes. I'm deeply obliged.
Much obliged.
Item number
My lord, may please lordship, this matter, my lord, relates to my lord, quashing the entire proceeding of my lord, PSC case number 879 of 2023, pending before the learned still Mr. Nagaon, my.
Actually, it's wildlife matter, I think. Wildlife special people will be there. They party one.
My lord, I have not making party, the complainant and the state, my lord. Otherwise, my lord, wildlife, yes, my lord, is there. But that is, I have silenced, my lord. Why it is not attracted, my lord?
But in the, you make them party if it is required.
Then I have to have copy to the public prosecutor of the wildlife, my lord, that is representing the forest department. If court pass an order, my lord, that. Oh, yes. My lord, then my lord, can you prepare for that? Wildlife or economic? Wildlife not. Because my lord, the offense, my lord, has been, my lord, while police registered a case, my lord, they has registered the case under, my lord, wildlife. Subsequently, that not initially. So that's why I have not made party to the forest department, my lord. They are nowhere involved except the offense, my lord,
Offense is
wildlife offense. But case is registered by the police, not by the forest official. They have filed any petition under section 55 of the Wildlife Protection Act. If because as per the Wildlife Protection, if forest
That
department
is your plea.
sees anything, my lord, they have to file a complaint petition under section 55 of the Wildlife Protection Act. So this police has on their which they have registered, my lord. That's why I have not been made part to them. They have to nothing to say also.
Actually, in the court below also, the original case has no wildlife department.
That is to go
no-
to the session judge, my lord. That is pending before the CGM, my lord. So there is no jurisdiction if, my lord, Wildlife Protection Act, my lord, penal provision 51 is, my lord, exacted. My protected case is that, my lord, if not be able to make, my lord.
Who is respondent number 2?
Who is the complainant, my lord, who lost the FR? He has no, my lord, grievance regarding wildlife, my lord. He has only, my lord, grievance is regarding sale of a vehicle, my lord. How the sale of a vehicle become a, my lord, Wildlife Protection Act and State Emblem Use Act, my lord, and using gadgets, these are coming, my lord.
But apart from wildlife offense, other IPC offenses are also there.
My lord. Yeah, my lord.
So you are challenging
All
only
those also, my lord.
all.
My lord.
So PP will also have to be appealed. So we are issuing notice.
My lord, I have an interim prayer, my lord, but next, that is case will be posted on 29 December. So Lord, this is not saying the minor proceeding, you have to fix earlier, my lord, prior to that. Consideration of my interim prayer, my lord.
But service of notice on respondents have to be completed.
My lord,
for consideration of
my lord, that is too much.
heard Mr. M. Saronia, Senate Counsel for the petitioner. Also heard Miss. Who will be appearing? B. Sharma.
Interim appear, my lord, both sides will cover.
Heard Mr. B. Sharma, learned additional public prosecutor. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 482 read with section 397/401 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Shri Mridu Pawan Nyok, praying for quashing the entire proceeding of PRC case number 879/2023 arising out of Nagaon PS case number 2328/21. Issue notice to the respondents as Mr. B. Sharma, an additional public prosecutor, appears for respondent number 1. No formal notice need to be issued to the respondent number 1. However, as regards respondent number 2, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD within 2 days from the date of this order, returnable on when
Maybe, my lord, this, my lord, 17, maybe, my lord, by 15 or maybe 18, 19, my lord.
18
Right.
18 of December.
My lord,
So the prayer
for interim.
for interim relief would be considered only after service of the consideration.
Right.
Let this get according to this.
My lord.
And regarding forest department,
My lord, forest
you may
department.
make submission on the next day. If
My
you
lord.
feel that
Other also, my learned friend is appearing, Lordship may indicate, my lord, in the order, my lord. Otherwise, he is representing
Then my
forest
lord,
department.
then my lord, he has to
no,
make
then
party.
let him go through the petition. Let him go through the
Otherwise, not needed, my lord. My, according to my.
Well, I'll go to.
you go through it,
Go ahead.
and if he has any submission, he may make.
Because
Ma'am.
forest, neither they have informed after seizing or something against commission of forest offense. The forest department no way involved, except the offense, my.
No, on the next day, on this point, you may make submission.
My.
Item number 12.
Lord, in this case, there exists a boundary dispute between the petitioner and the respondent. The first in time, my lord, petitioner number 2 hearing, Mr. Professor Pegu closed the FIR, which was registered as a GD entry, and upon investigation, that my lord will find a page 14. And upon
No,
investigation,
just
page 14, my lord. My lord. And police registered a non-FIR case, which my lord will find at page 18 on investigation. And drawn up a proceeding under 107 and 145, since there is a breach of risk in that area. And as a counter to said case, the respondent number 2, the informant hearing against which they have lost the FIR, as page 26, my lord will find on 16/3. My information was of 13/3. And this case has resulted in after investigation into FIR, final report, which my lord will find is page 32, my lord.
which case has resulted in
26 page number that one.
26, my lord. Against this FR was filed, and against the FR final report, the informant respondent number 2 has filed a protest petition, which has been treated as a complaint, and upon that complaint petition, cognizance has been taken. I have agreed with that cognizance, because I will thought that on the basis of the improved statement in the protest petition, and on the basis of the contradictory statements of the witnesses, which has been examined under
Okay.
200.
Okay, let us see.
Yes. And my lord will kindly see.
No, we are issuing notice.
My lord, there is no act of attribution has been made against the petition number 2. At least he may be protected, my lord, and LCR may be called for.
No, at what stage that
It is for the appearance at the first stage appearance. That we have received the someone, and upon someone we have approached the court.
Then the notice we issued, then appeal notice, then lot
when the
may-
next date is
Next, it is on Monday, my lord, on 20.
Mr. E. Jadan, and the counsel for the petition. Also heard Ms. A. Begum, and the additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Anu Pegu, Kargeshwar Pegu, and Hirokyuti Pegu, praying for quashing of the complaint case number 8/2023 under section 341/427/506/34 of the Indian Penal Code, which is pending in the Court of London, Subdivisional Judicial Magistrate Unit. Issue notice to call for the scanned copy of the case record of complaint case number 8 of the 2023 from the Court of London, SDJM Jonai, and issue notice to the respondents. The petitioner shall take steps for issuance of notice on the respondent by registered post within 3 days from the date of this order, returnable after 3. The prayer for interim relief would be considered only after service of notice.
The next date is on 20. Till returnable date, I may be protected. Till returnable, I
No.
take the step today itself.
There is
Up to 3 weeks, my lord, I may be. Only up to the returnable.
after service of
notice.
On Monday, I have to
appear.
If I work here, I have to go on bail.
And if
Only up
one,
till
one day may
only
be
up till
taken
returnable
for
date, I may be protected. Only after this.
a day may be taken for adjournment.
No, only summons have been issued against. We will consider your nothing imminent urgency is there that you cannot. This case is not of such an urgent case where interim relief.
LCM may be called for notice for registry.
No, I have passed on scan copy of
Lordship.
registry will take steps for requisitioning the scan copy.
Interim will be considered after later.
May please, maybe pass over for the time being. The time being, senior is on leg at port number 15.
May please, Your Lordship. So the property application lawsuit, the page at page 7 lawsuit. The allegation is non-believable section, only one non-believable section, 386 lawsuit. The FIR lawsuit and page 7 lawsuit. The allegation is that lawsuit, the petitioner lawsuit has intercepted a vehicle carrying cattle lawsuit and handed over the police lawsuit. As per the FIR lawsuit, the incident took place at 11
What is
p.m.
386?
lawsuit.
386 is there.
386 lawsuit. One vehicle was intercepted by the petitioner who was carrying cattle lawsuit and handed over to the police
Extortion.
lawsuit. And then lawsuit, what happened, the owner of the cattle lawsuit, he has paid money late night lawsuit to one joint budget board lawsuit. Petitioner before your lawsuit is not a joint budget board lawsuit. I have also annexed the transaction receipt lawsuit, page 10 onwards lawsuit. It was paid by Google Pay lawsuit to one joint budget board lawsuit. 23,000 has been sent by the owner of the cattle lawsuit. And then on the next day, lawsuit, he has closed the insurance FIR lawsuit. Your
CD
lawsuit,
is required, Lord. At this is
lawsuit, I have annexed the lawsuit, the money transaction receipt lawsuit. At page 10
What
onwards.
is your name?
My name is lawsuit,
Abhijit.
Vijay Chronicle lawsuit.
But you are also, allegations are against you also.
Yes, lawsuit, yes, when he has made allegation against me, but lawsuit, the incident took place at 10:30 a.m. p.m.
No,
lawsuit.
but there is specific allegations against.
against
Lawsuit, 386 lawsuit, so far 386 lawsuit. Lawsuit, if the money is extorted by putting K of death, then lawsuit 386 will come lawsuit. Then here lawsuit, the incident took place at 11 p.m. lawsuit, and money was sent on 1:30 a.m. lawsuit. So lawsuit, kindly see the FIR page 7 lawsuit.
No, hard mistake. Let us verify.
Since the money has been sent.
We are
CB on 29/11.
Short date we are taking.
29/11.
Hard
It is
Mr.
বলে
TC,
রেখেছি
yeah,
আপনারা।
learned counsel for the petitioner, also heard a leg up, learned additional public prosecutor. Considering the
29
nature of allegation
29 কি হবে?
leveled against the present
Monday?
petitioner in the FIR, perusal of the case diary would be necessary for consideration of statute application. Hence, call for the case diary, fixing 29.
11.
Oh, legend.
May I please, Your Lordship. Well, here, the present affair is a counter blast affair. Well, between the party, well, dispute was arised on 15/10/2023 at about 10:30 or 11 o'clock, my lord, in daytime. What happened, my lord? The informant side that affair is page 11. My lord, the informant party, my lord, illegally entered. Page 16 is our affair, my lord, into the premises of the present petitioner. And, my lord,
When the FIR against you was filed,
my lord, same day both party filed, but our case
on
was-
which date?
my lord, here is 23/10, my lord. So 22/10, my lord.
22.
And after 7 days, my lord, both affair file
On
was.
this date,
The CDB therefore both the cases
And, my lord,
326 is there, Lord.
except 326, other section is available, but nobody sustained the, well, previous injury. Our side also and their side also. Our case was registered first time, and subsequently, my lord, by pressure of them, my lord, the present affair was registered. Though affair was filed in same day, but police found that our case is valid, my lord. Accordingly, first time our case is registered, and some people, my lord, go to the police station and pressurize the police. Then, my lord, the present case is registered. My humble submission, my lord, none of the party, my lord, sustained the grievous injury. 326 will not come here. Admitted fact, my lord, there is a dispute, and, my lord, initially it was altercation, thereafter, my lord, some fella has a like, my lord, but both party lost the affair.
no, your plea submission is 326 would not come.
My lord. 326 will not come. Other, all section is valuable. Though police registered, but I am confirmed, my lord, because nobody admit in the hospital, my lord.
Jagar and
But
iron.
allegations are
The
there.
allegations
But
Jagar and
our
iron.
application also this way, my lord. So, my lord,
Both the
subsequently,
You
the
have,
cases.
you have also alleged 323.
Yeah.
Let us peruse the case then.
The it may be given because if found on a grievous injury, our case will be.
No, we will
Bracket
fix shortly.
Well, all the family members may not some problem. Because in our case, 326 is not given, 325 given, and against us only 320. That is the problem. And my lord, both parties sustain simple injury. My lord, find something happen,
No,
my lord.
there is allegation of fracture also
Right, my lord,
in a
They were taken to Barpeta Medical
Yes.
College. At present, 2% are in critical condition.
as per my instruction, my lord,
let us,
the grievous injury will not come.
but
Maximum,
whether
my
your information is true or not, we have to go through the.
And another point, my lord, that subsequently register. So we can, my lord, say that it is counter blow. Because the police immediately not registered the case, man. Because our case is 396 and against us is 398.
Heard Mr. N. Green, as a counsel for petitioner. Also heard Ms. A. Begum as a petitioner for appeal. Considering the nature of allegations leveled against the present petitioner in the FIR, perusal of the case diary would be necessary for consideration of the instant bail and distributed. Hence, call for the case diary
2911.
fixing 20. On that day, we will
But in both the cases,
case diary of both the cases would be required.
Hmm.
No, not
uh,
required. Not
required because you
because you have already submitted that. You have filed it. That we will take
325 is there. So
of this case on 29.
29.
2911 senior medical one, CD and medical.
Case diary in, and the injury.
I'm all right.
May I plead your lordship? This is a 438 application, your lordship. So, under section 326, 307 and 34 of IPC, registered as Gosaigo PS case number 316 and 360 of 2023. Also, may I plead the FIR?
Yeah. 307.
Yes, yes. The translated copy of the FIR is in the page number 10, your lordship.
With a chopper causing severe blood
Yes.
died injury
There are
all over the body and made an attempt to
case diary would be
case the CD and injury report.
3 co-accused are already granted bail, your lordship. Your lordship, the actual fact is that, your lordship, the accused petitioner and the informant and the accused petitioner are brother, your lordship. Your lordship, after that of the
named accused were granted bail.
your lordship,
3 named accused.
yes, your lordship. 3 FIR named accused were granted bail, your lordship.
There are only 4 FIR named.
Yes, 3 were granted bail and he's the last one, your lordship.
Your name is?
Rafiqul,
You are number 1.
yes. Rafiqul Islam, your lordship.
But allegation is against
Your lordship, the informant and the accused petitioner are brother, your lordship. After that of the father, after the death of their father, your lordship, the informant and the other brothers of the accused petitioner ganged up and gave a lesser share of the land, your lordship, to the accused petitioner. Lordship, thereby denying him the share of the property he is legally entitled. The accused petitioner has been trying to convince his brothers to his relative and villagers to divide the inherited property equally. On 8/9/2023, the villagers had planned to gather at the informant's residence for a civil discussion regarding aforementioned dispute or lot. However, just before the meeting, the accused petitioner saw the informant Sufizul Islam attempting to leave their home in order to avoid the meeting a lot. When the accused petitioner attempted to prevent them, a scuffle between among the brothers escalated, your lordship.
Lordship, the bail record order is there, Lordship. Earlier bail granted. After going to the case there, Lordship, the material collected also suggests that, Lordship, they were not present, Lordship. Those 2 persons were granted bail. They were not present at the time of the occurrence, Lordship. So let the CD will be required, Lordship, whether his footing is in the same thing or not. Page number 23, Lordship. The material collected also suggests that they are not present at the
Now,
place of
what is the
occurrence.
sufficient? You are also not present.
That will have to go to the civil, Lordship.
Lordship, but the 3 co-accused were already granted bail, your lordship. I'll cooperate with the investigating officer and we will protect your lordship.
29, Lordship, we will bring a short date, Lordship. If there is nothing, he will grant bail.
This is a familial dispute, your lordship, over a plot of land. There was no intention, your lordship. They attacked us, and we tried to protect ourselves. Your lordship.
One was not present and for another accused, no such observation.
Yes.
At page, let him appear. Read page 20. There are 2 bail orders.
Two, Lordship.
2 bail orders. For one, there is a specific observation that he was not present.
Lordship.
For another, there is no such observation. But he is also on bail.
That is, Lordship, that these 2 persons, those 2 petitioner was there only, Lordship. Abdul Wahab and Sona Bhanu Bibi.
And Nur
After the
Islam,
affair,
Nur Islam.
he was arrested, but he was also granted bail, your lordship.
Heard, Mr. A.W. Aman.
I'm on behalf of AW.
What is your name?
S. Rahman.
S. Rahman.
Yes.
Learned counsel for the petitioner. Also heard Mr. A. Begum, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Rafiqul Islam, who is apprehending his arrest in connection with Gosaigaon PS case number 316/23 under section 326/307/34 of the Indian Penal Code. The gist of accusation in this case is that on 8/9/2023, one Nur Islam, one Rahimuddin Sheikh had lodged an FIR before the officer in charge of Gosaigaon Police Station, inter area, alleging that on 8/9/2023 at 4:30 p.m. during the absence of the brother of the informant in his house, the accused persons named 4 numbers of accused persons named in the affair, including the present petitioner, trespassed into his house and assaulted the wife of the first informant and his younger brother, causing injuries all over their body. Learned counsel for the petitioner has submitted that the petitioner is not involved in any manner in the offense alleged against him in the FIR. It is further submitted by learned counsel for the petitioner that the petitioner is the brother of the first informant, and there is a family dispute between the petitioner and informant. It is also submitted by learned counsel for the petitioner that in the meanwhile, other three named accused in the FIR have already been granted bail by this court. Stop. On the other hand, learned additional public prosecutor submits that considering the nature of allegations leveled in the FIR against the present petitioner, perusal of the case diary would be necessary. Hence, call for the case diary. However, considering the fact that the other three petitioners are already other three co-accused persons
One was B. Nur Islam was B. Like, he was
are
the
on
leader.
bail,
Are on bail.
are on bail, and the petitioner is ready to cooperate in investigation, he is directed to appear before the investigating officer of Gosaigaon PS case number 316/2023 and cooperate in investigation within 10 days from the date of this order. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Gosaigaon PS case number 316/2023, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, rupees 50,000. Others are given rupees 50,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Number one, that he shall not directly or indirectly make any promise, inducement, or threat to any person who may be acquainted with the facts of the case so as to dissuade such person from disclosing such facts to the investigating officer. That he shall cooperate in the investigation. Let this case be listed again on
Lordship 1512, Lordship.
15/12. এই admission বিলাক যদি দীঘলীয়া hearing
Number 8.
long hearing bail hearing বা মাতৃ দিব
Wait, please, your lord. Well, I'm sorry, actually, I was at the part of matter. I'm sorry. The 438 application, your lordship kindly see page 10, my lord, annexure 1 is the FIR. I am a insert secretary for that particular Gaon Panchayat. Only for 8 months I was there, my lord. I'll come to the fact with my lord. Your lordship kindly see annexure 1, page 10 is the FIR.
Yes.
With reference to the above, I kindly lodge an FIR against Sri Sukuruddin Borbhuya, Assistant Block Development Officer, Kothelakusi Development Block, then ICGP Secretary of Badlabadli Nagadam GP, Sri Ashok Kumar Nunia, accredited engineer of the so-and-so GP who was transferred from Block 5 GF in the Assam order so-and-so, and Bodar GP border so-and-so, under Korimganj Jila Parishad so-and-so. The FIR is to be lodged on misappropriation of fund under 14 Finance Commission, granted Bodlabadli Nandagram GP level, as highlighted by the letter or an inquiry report received from the Commissioner, Panchayat and Rural Development of Assam Bhait under reference. We are therefore requested to kindly look into the matter, take necessary action as per law. And after this, my lord, my lord, the case has been registered, page 11, your lordship, kindly see, 120B, 406, 409, 420, and so. In the FIR, my lord, only name was there, nothing there, your lordship, kindly see the inquiry report, my lord. Inquiry report on the basis of which this FIR was lodged, and that, my lord, your lordship will find it page 18, my lord. Page 18, my lord. Page 18, my lord. Inquiry report on alleged anomalies in implementation of 14 Finance Commission scheme at Badla Badli, Nagagram, GP South Hailakandi Development Block, Hailakandi District. Introduction. In pursuance of the office order dated so and so, and myself and along with the Polas Talukdar assistant engineer and had proceeded to Badla Badli, Nandagram, GP South Hailakandi Development Block under the Hailakandi District so and so. In the inquiry was accompanied, the inquiry team was accompanied by, cited by Sri so and so, and GP Secretary so and so, Sri Supur of the GFC Secretary, Badabali, Nagan, assistant so and so. Backdrop of the inquiry, your lordship kindly see, the complaint letter addressed to the Principal Secretary, PNNRD, Assam Uddin Law Court President, Jana Soikni Sabha Committee, Assam has submitted a reminder in respect of their earlier complaint letter dated Sunday, where it had submitted a list of the 5 numbers of scheme under 14 finance executed in Badla Badli, Nandagam, the Gaon Panchayat under South Hailakandi block. A complaint added so and so. So, scheme, my lord, that is a scheme under serial number 1, serial number 2, serial number 3, serial number 4. My lord, your lordship kindly straightway goes to my lord. Finding of the observation. Page number 20, my lord.
Yes.
It is observed there the scheme under private preview of the inquiry are taken up in the Gaon Sabha and subsequently sanctioned and executed without bearing in mind the particularly the such scheme on the backdrop of hilly terrain of the area having scarce water source of resulting the waterage of the government fund. The concerned video, so I am not video, my lord, who should have analyzed the list of scheme before passing the BLAMC meeting and for approval. Second, as per section 4.3 of the Assam Panchayat Act 1994, every meeting of Gaon Panchayat may be presided over by the president of the concerned Gaon Panchayat and his concern in absence of vice president of any person to be selected by the majority of the Gaon Panchayat member for the meeting. But in the it is observed that on that case of GPDP Gaon Panchayat held on 1/11/2019 in Badlamari Nandagam Gaon Panchayat, the minute of the meeting was approved by Abdul Kalam Mozumdar, the husband of the Gaon Panchayat president Rasmana Begum Mozumdar, but it was not clear whether the GP president was present in the Gaon Panchayat or not. It is if so, what about whatever the said Gaon Panchayat held in the within due approval from the Gaon Panchayat president? So it seemed that violation of section 40 of the Assam Panchayat Act 1994. It is also worth mentioning that during the inquiry, the Gaon Panchayat president did not cooperate with us, and instead of her husband Abdul Kalam Mozumdar had tried to mislead by the inquiry team. Minutes of the said so and so. So it is observed that the Gaon Panchayat president of the husband of Abdul Kalam Mozumdar was in the chairman of the construction committee constituted smooth implementation of the 14 Finance Commission scheme so and so. The scheme, my lord, 2016-17, 17-18, 18-19, and 19-20. Thus implied, page 21 is very important, thus implied that fact that as both Gaon Panchayat GP president and her husband are involved directly in Panchayat payment of in case of 11 numbers of construction committee. So both of them are also directly involved in misuse of 14 Finance Commission fund, thereby causing violation of 14 Finance Commission guidelines. Conclusion, very interestingly, my lord. Conclusion, based on the on-site technical assessment of the assessment visited as elaborated above, scrutiny revealed and record testimony of GP and block level official, PRI member and local people, it can be inferred that one Sukur Ali, who is the person here, my lord, petitioner here, assistant block development officer and the GP secretary and Bodla Bodli Nagagam GP and to Asuk Kumar Nunia, the accredited engineer primarily responsible for misuse of the FN funds Assam so and so. Accordingly, legal action may be initiated against GP president and Sunara Mazumdar and the husband of the Abdul Kalam Mazumdar for misuse of the power as well as fund. Both are directly involved in the payment of 11 numbers of 14 finance commission as well as the instrument of the Gaon Panchayat secretary, hereby causing prejudicial to the lapse on violation of the 14th Finance Commission guidelines and also violation of the Assam Panchayat Act 1994. My lord, your lordship, kindly see this inquiry report, my lord. I am, my lord, in search for only for the period of 8 months. Your lordship, kindly see. And my lord, in my period, that is not been happened.
You are assistant block development officer.
Assistant block development, that point of time, I am not assistant block development. Now, your lordship, kindly see that your lordship, kindly see my order of appointment, page 24, my lord. And except 4, my lord.
Yes.
And except 4, my lord, your lordship, kindly see serial number 5. Serial number 5.
Yes.
It partial modification of the earlier order, office order dated so and so, the interest of the public serves the following Gaon Panchayat secretary, accountant cum storekeeper are hereby directed to take temporary additional charge of the addition of their normal duties. Sukuruddin, serial number 5. So, Porisolna Santani Sara Gaon Panchayat to Badla Bodli Nandagam Gaon Panchayat. So, that is from 9th January. And I was, my lord, promoted to the, my lord, post of assistant block development officer in the by order dated, my lord, 19. So only for 8 months I was there. So inquiry revealed that, my lord, everything is been done by president of the Gaon Panchayat and the husband of the president of the Gaon Panchayat, and the meeting which was held, my lord, your lordship kindly did in an inquiry report 1/11/2019. In 1/11/2019, I was not there, my lord. So that is my promotion order, my lord. So I am not now at present. I am not there, my lord. Only for 8 months I was there, my lord. I stated in my
Meeting was held on
my lord 1/11/2019, and that revealed from the, my lord, inquiry report. But at 1/11/2019, I was not there, my lord. Page 4, para 5, my lord. I have stated on oath, my lord. So now, my lord, very interestingly, inquiry revealed that, my lord, everything has been done by the president of the Gaon Panchayat and with her husband. But very interestingly, my lord, FIR was lodged against whom, my lord? Insert secretary and, my lord, one engineer, my lord, accredited engineer. There, me inquiry report, my lord, your lordship kindly see in the conclusion also, it can be inferred. The only that line, my lord. Conclusion of the entire, my lord, inquiry report, my lord, page 21. I'll read again, my lord. Conclusion: based on the on-site technical assessment of the scheme, visited as elaborately above, inquiry revealed that the testimony of this Gaon Panchayat and block development officer, it can be inferred that Sukuruddin, assistant block development officer, and the GP secretary and then GP secretary, Badla Bodli Gaon Panchayat, and one Asuk Kumar Nath, accredited engineer, are primarily responsible for the misuse of the funds. My lord, it can be inferred, but in earlier, my lord, finding your lord, secondly, this implied that the fact that both the Gaon Panchayat president and her husband are involved in directly in payment in case of 11 numbers of construction committee, as also both of them are directly involved. So against them directly involved, our second one is that conclusion inferred. My lord, your lordship kindly see FIR lodged against these 2 persons only, not other, my lord. They are not name accused, but they are not, the FIR is not lodged against them, my lord. So your lordship kindly see the FIR, not page 10, my lord, now.
Okay, let us call for the case.
Case diary, Lordship, case diary.
So I may be protected, my lord,
Lordship,
only for
after
9
that-
period, and my period has not been happened. That is my only submission, my lord. And in fact, my lord, how they twisted, my lord, even my lord from the higher authority,
Presently, where are you?
my lord, presently, Southern, South Hailakani Development Block. That, my lord,
As
that is your lordship, that I have produced one, my lord, that is serial number 93, my lord. Serial number 93.
you are working as
Working as a, my lord,
assistant video.
additional block development. Now I am working as
Assistant.
additional.
Additional or assistant?
It is assistant, sorry, my lord, assistant block development officer.
Earlier also you assistant block.
No, I am a president. I was, now I'm,
You
now
must
earlier I was
secretary.
insert secretary.
In charge
Insert for
secretary.
8 months.
Lord,
In that
Lordship will bring the city in short date, Lord.
No, let him appear. You bring the city in this. Let him cooperate.
And my lord, in fact, all the documents is up to
The
19, my
anomaly
lord.
is about
Where is the FIR?
FIR page 10, my lord. Page 10, my
When
lord.
it was lodged?
It was lodged on 23/8/2023. And directly in the name of 2, my lord. But regarding my lord, president and nothing.
Now, why are you apprehending your?
My lord, I am apprehending matters, my lord, but police is called for the police station, my lord. I am the name accused, my lord. But on the inquiry report,
Otherwise, you are a government servant.
Lordship.
my lord.
Heard Mr. T.J. Mahanta, the senior counsel assisted by R.A. Chaudhary.
Actually, it is the
Also heard Mr. A. Begum, learned additional public
case
prosecutor.
number 2 the city kon call korbo lagi hadi bole.
This application under section 438
Didi
of
case number 2
Code of Criminal Procedure, 1973 has been filed by the petitioner Sukur Uddin, who is apprehending his arrest in connection with Ramnathpur PS case number 132/23 under section 120B/406/409/420 of the Indian Penal Code, corresponding to GR case number 922/23. The gist of accusation in this case is that on 23/8/2023, 3P Dwara Block Development Officer, South Hailakandi Development Block, Manipur, lodged an FIR before the officer in charge of Ramnathpur Police Station, inter alia alleging that you are named in the FIR.
Yes, that's why, my lord. Your lordship can see the 2 names there, my lord.
You are not named in the inquiry of report.
In inquiry, my lord,
It
conclusion
will
is
ask-
that
okay.
it can be inferred.
Inquiry also report.
Inquiry against my lord, and in inquiry, my lord, it clearly mentioned about the, my lord, president and the husband of the president. But my lord, it can be inferred. The only line is there. That is in conclusion.
Inter alia alleging that the present petitioner, who was the then in charge
Secretary.
Gaon Panchayat secretary of Baldi Nardigram GP, and
No.
one Ashok Kumar Nunia, the then accredited engineer of state GP, have misappropriated funds under 14th Finance Commission grant of Baldi Nandagram GP as as found in the inquiry report received from the Commissioner Panchayat and Rural Development Department, Assam. On the basis of the said FIR, Ramnathpur PS case number 132/23 was registered. Learned counsel for the petitioner submits that the FIR has been registered on the basis of an inquiry report submitted by Assistant Development Commissioner and Assistant Engineer regarding alleged anomalies in implementation of 14th Finance Commission scheme in Boldi, Nandagram GP of South Hailakandi Block Development Hailakandi. South Hailakandi Development Block, Hailakandi. It is submitted by learned senior counsel for the petitioner that on perusal of the said inquiry report, it would be apparent that the findings of the said inquiry report directly implicate one, the president of the said GP
And his husband,
and
Mr. Modi.
her husband, Anamud, who is the president,
Abdul Kalam Muzumdar. Her husband, Abdul Kalam Muzumdar, and
her
Lusnara Begum Muzumdar is the president.
and her husband
Abdul Kalam
Abdul
Muzumdar.
Kalam Majumdar.
But the FIR was not
The president of the GP, namely Rusna Begum Majumdar and her husband Abdul Kalam Majumdar. And only in the concluding part of the inquiry report, an inference has been made that the present petitioner may also be involved. However, no basis for such inference is there in the inquiry. Learned counsel for the petitioner has also submitted that the petitioner was working as the in-charge secretary of the
Boldi
Nandagram Gaon Panchayat on 9/1/2020, and he remained as such till 10/9/2020 when he was promoted to the post of assistant development. How this period is relevant?
My lord, this period is living on everything has been happened, my lord, prior to that, my lord. Your lordship kindly see in the inquiry
Learned
report.
counsel for the petitioner submits that the inquiry report shows that the alleged misappropriation of fund had occurred prior to the period when the present petitioner functioned as in charge secretary of Boldi Nandagram Gram Panchayat. Learned counsel for the petitioner has also submitted that the present petitioner is presently the petitioner is posted as an assistant BDO,
Assistant Block Development Officer,
at Kartichara
Development Block, Hailakandi.
and he is ready to cooperate in the investigation. So, on the other hand, learned additional public prosecutor submits that since learned additional public prosecutor opposes the grant of bail to the present petitioner on the ground that this case involves misappropriation of huge misappropriation of public funds. And she further submits that perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary fixing
Lordship, 14/12, Lordship.
14/12/2023. However, considering the fact that apparently, considering the submissions made by learned counsel for the petitioner and considering the inquiry report which has been placed before this court as annexure, which has been placed before this court along with the bail application, as well as considering the fact that the petitioner is ready to cooperate in the investigation. The present petitioner, namely Sukuruddin, is hereby directed to appear before the investigating officer of Ramnathpur PS case number 132/23 within 10 days from the date of his order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with the Ramnathpur PS case number 132/23, he shall be allowed to go on interim bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. That petitioner shall appear before the investigating officer as and when so required by the investigating officer for the sake of fair investigation and shall cooperate in investigation. Number 2, the petitioner shall not directly or indirectly make any inducement, threat, or promise to any person who may be acquainted with the facts of the case so as to dissuade such person from disclosing such facts to the investigating officer. Let this case be listed again on
14/12.
14 December.
Supplementary.
FIR is at page 10, my lord. So my incident was took place on August, my lord. The FIR is filed on my lord. 310, my lord. Page 10 is the FIR, my lord. So my lord, 307 325 has been attacked, my lord. But my lord, the informant is my lord conscious of that my lord, he did not get the my lord monetary relief from the informant, my lord, from the accused person, my lord. Allegation is that my lord, the informant's son was assaulted by some person in railway station, my lord, in the guise of stealing a mobile phone, my lord. Thereafter, the employer of this, my lord, the petitioner, my lord, helped them by monetary help, my lord. In page 11, my lord, the last paragraph, my lord, see, my lord, that the informant did not get the monetary help from. So the informant's basic defense is that, my lord, though the employer has gave them a assurance, my lord, that he will be, my lord, providing monetary help, my lord, but she did not receive, my lord.
দেখিলো কিন্তু তাৰ এখন ভৰি ভাঙিছে ন ট্ৰিটমেন্ট কৰিব কাৰণে one leg is broken Lordship.
Now, kindly see, my lord. We are not the, my lord, any employee of a Easter, my lord. We are the employee of a Pentica, my lord, who was operated by this one company, my lord, Gihon Private Limited, my lord, in a railway station, my lord. And case 16, my lord, that is the compromise deed, my lord.
And broke one leg, Lordship.
Case 16, my lord, kindly see, my lord. The employer has gave her assurance, my lord, that they will provide the monetary help to the informant, my lord, for medical treatment, my lord. This was on my lord 31/8/2023, my lord. And the FIR was filed on 310, my lord, in October, my lord. Now, my lord,
When the incident occurred?
29/8, my lord. Now in page 90, my lord, she
And
received
when
like
the
1 lakh.
FIR was lodged,
My lord, FIR is loss of 310, my lord, in October, my
okay,
lord.
there is a delay of 3 months.
Yes, my lord. Now in page 19, my lord, she received 1,25,000, my lord.
No, we are not concerned about
Yes, my lord.
let him appear.
Yes,
Because there is a delay of 3 months.
yes,
Lordship, till the CD lordship.
obviously, my lord.
Third, Mr.
Yes,
S.
Lord.
Bodhakur, learned counsel for the petitioner. Also heard Ms. A. Begum, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Umesh Kushwaha and Vasudev Dhar, who are apprehending their arrests in connection with Guwahati GRPS case number 191/2023. So the gist of accusation in this case is that on 3rd of October 2023, one Musammad Tara Banu lodged an FIR before the officer in charge of GRPS Guwahati Railway Police Station, inter alia, alleging that on 29/8/2023, 4 employees of a shop inside the platform number 4/5 of the Guwahati railway station assaulted the son of the first informant, Muhammad Mahar Ali, and caused injuries on his person. It is further stated in the FIR that after the incident, a compromise was entered into by the parties and a deed was also executed to that effect, wherein it was mentioned that the expenses borne by the informant in treatment of her son would be incurred by the who will incur the expenses? By the petitioners. However, they have not complied with the deed of
Employee of the petitioner. They are the employee. The keys to our name,
Learned counsel for the petitioner submits that regarding the allegation of assault, what is your submit?
But I have yesterday, man, they are the employee of one petty car, while on 28 minutes, the train was boarded at railway station, they saw, my lord, that because one person was manhandled by some person, my lord. That was also in the compromise deed also, my lord. It says, man, some general people have assaulted her son, my lord.
You have not assaulted?
No, my lord.
Okay. Learned counsel for the petitioner has submitted that the allegations leveled against the present petitioners in the FIR is not true. In fact, the son of the first informant was manhandled by some general public in the railway station, and it is also submitted that in pursuant to the, where is that 1 lakh you have paid?
Page 19, my lord.
It is also submitted that in pursuant to the compromise agreement entered into between the first informant and the owner of the shop in which the present petitioners are employed.
Yes.
An amount of rupees 1,25,000 have already been paid to the first informant. It is further submitted by learned counsel for the petitioner that the FIR in the instant case has been lodged after a delay of about 2 months.
2 months.
2 months. and it is further submitted that the petitioners are ready to cooperate in the investigation. CD would be required.
CD.
Learned, on the other hand, learned additional public prosecutor submits that perusal of the case diary would be necessary considering the nature of offense involved in this case. Stop. Hence, call for the case diary. Fixing
1512, Lord.
fixing 15 12
After
for
15,
case.
12 months, 52, I-
The 19, Lord. 19.
Fixing 1912 for case diary. However, in the meanwhile, considering the fact that the FIR has been lodged after a delay of 2 months and there is a deed of agreement. There is a deed of agreement. A deed of agreement has also been executed between the informant and the owner of the shop in which the present petitioners are working. Comma. This court is of considered opinion that at this stage, no, this is not required. Comma. The petitioners, above named petitioners are hereby directed to appear before the investigating officer of GRPS case number 191/23 and cooperate in the investigation within 10 days from the date of this order. Stop. If they do so within the stipulated period of time, comma, in the event of their arrest in connection with GRPS case number 191/2023, both the above named petitioner shall be allowed to go on interim bail of rupees 30,000 each with one surety of like amount subject to the satisfaction of the arresting authority.
Yes.
With following condition, same condition number 1 and 2.
Public.
Let this case be listed again on
On
19.
1912.
19th.
May speech, Your Lordship. My lord, this petition, this petition under 482, my lord, is for my lord passing of a
This
affair
is
against
for final
my lord.
final disposal. Okay. How much time will it take?
Not long. I'll take about 15 minutes now.
Okay.
Then, my lord, one thing, my lord, actually with me, my lord, one affidavit, the reply of the affidavit in opposition, my lord, except that, my lord, I have no any record with me, my lord. And my lord, the inquiry report was also called for, my lord, in the previous occasion, my lord.
Actually, my lord, what had happened, there was a recruitment process where, my lord, I had no role.
No, I want to know
Huh.
whether can we go ahead with hearing.
Yes.
now.
My lord, because they have filed their affidavit, in the affidavit, their stand is there. Other than that, they cannot have anything more, my lord. Their affidavit is on record.
Or let the petitioner side make submission.
Yes.
You reply tomorrow. Or day
Yes,
after.
yes, yes. My lord will kindly come to the FIR, my lord.
Yes.
At that relevant point of time, my lord, the petitioner was additional superintendent of police, headquarter, Nagaon.
FIR is that page.
Page number, my lord, 22.
Prayer is for quashing of the.
Quashing, my lord, the petitioner. I'll show, my lord, there are absolutely no materials.
Page number
22.
Yes.
With due respect, I beg to state that based upon news items published in different local newspaper regarding malpractices adopted in recruitment process of AB constable in the year 2015 in the district of Dhubri, Borpeta and Nagaon, a discrete inquiry was initiated and conducted from the side of Vigilance and Anti-Corruption Assam. And after preliminary inquiry, a regular inquiry was initiated at the instance of the government approval by dated 23rd of July 2015 by forming a SIT headed by Superintendent of Police, Vigilance and Anti-Corruption and other members including myself. The SIT on regular inquiry, it is found that below noted persons under a criminal conspiracy have made wrong manipulated records instead of free and fair interview by abusing their official position for their wrongful gain and thereby committed criminal breach of trust and cheated in the process of recruitment of AB constable in the district of Dhubri, Borpeta and Nagaon and submitted its finding to the government of Assam. Accordingly, government of Assam was pleased to order by dated 5th of May 2016 to register a criminal case against the below noted person. I therefore request your honor to kindly register a case against the below noted person under proper sections of law and arrange investigation. Your lordship will kindly come to the next page.
Who is petitioner?
This serial number 4, my lord. Hitesh Roy, APS, the then Additional Superintendent of Police Headquarters, Nagaon District Executive Court. Now, my lord, this is the allegation. Now, if your lordship will kindly come to page number 24, this was a communication which was issued by the police headquarters, my lord. Now, this is of 24/12/2014. The following district level selection committees have been constituted to conduct all tests and other processes in connection with recruitment for 6748 post of AB constable in the state of in Assam Police. Now, if your lordship will kindly come to page number 27, my lord, serial number 18, Nagaon district, page 27. Okay. Nagaon district, Aurobindo Kolita, IPS, SP Nagaon, Sri Arnab Deka, APS, Commandant 9 APBN, one senior medical officer to be nominated by Director of Health Service Assam. So, as far as recruitment of constable in Nagaon is concerned, my lord, these were the three persons who, my lord, were in charge. Now, my lord will kindly come to the page 29. The role of the district level selection committee. In fact, lordship's continuation of the same communication.
Page number 20.
Page 29, my lord, first subparagraph. The district level selection committee will be fully responsible for implementation of the said guidelines in letter and spirit. After completion of all the tests, etc., state level police recruitment board will approve the select list of candidates for appointment as per existing rules. All papers and digital records will remain in the custody of the superintendent of police of the concerned district. Similarly, all equipment and computer hardware, etc., procured and used during process will remain in the custody of the concerned SP under a proper inventory. The Range Inspector General of Police, Deputy Inspector General of Police will act as a co-opted member of the state level police recruitment board within the range and will ensure proper implementation of the rules and guidelines. So, my lord, in the scheme of that selection process, my lord, three persons were there, and it is their responsibility or duty, my lord, to make the selection. And my lord, but the lordship will rise for 5 minutes. Yes,
I'll take break for one.
No. Yes, sir. কি দেখে তাক সাজা হব না তাৰ কিবা আছে গণ্ডগোল গণ্ডগোল নাথাকে
অফিচাৰ ইনভেষ্টিগেশ্যনত কিবা ওলাইছে চাগে পিছত ইনভেষ্টিগেশ্যনত কিবা ওলাইছে
একোই নাই
মোৰ লগত ইফালে নাই মই
খালি এটা ফাইল হলে কি হ'ব কিন্তু চাৰ্জ ফ্ৰেম কৰিব নোৱাৰিব এইটো কেছ আচ্ছা মই যদি পইচা লৈছো মোৰ গেছে এলিগেশ্যন পইচা লৈ তাহলে মোৰ হেৰি হ'ব লাগিব তাৰে কোনোবা মেম্বাৰৰ লগত মোৰ এটা কলিশ্যন লাগিব একো নাই মোৰ মতে একো থাকিব নালাগে মানে মিত্ৰ এক্সেক্টলি মই ক'ব বিচাৰিছো আনলেছ 120B is attractive or 34 is not how can you তাৰমানে অৰবিন্দ ৰাভাৰ মেইন চহী কৰা মানুহটো সি লাগে অৰবিন্দ কলিতা তাৰ গেছে একো নাই এটাৰ গেছে অনব দেখাৰ গেছে আছে মই কাৰোবাৰ লগত ট্ৰান্সফাৰ কৰিব লাগিব তেতিয়াহে মই পাৰিম ও নামাজ নাই নাই
Please, Your Lordship. I have a small prayer, Lordship. May I pray, Lordship, item number 19 and 20 may be taken at two, Lordship. I would highly pray, Lordship. Item 19 and 20, Lordship. With due respect, Lordship.
Okay.
At two, Lordship.
Item 19 and 20 is what, ma'am?
Admission, Lordship. Just after my learned seniors.
Admission.
Item
Long hearing would be required.
Lordship.
We will take up admission matter after bail hearing.
Lordship. Lordship.
After this, we will take up bail hearing matter.
Lordship.
And thereafter admission.
If suppose to Lordship.
Otherwise, we will not be able to take.
Lordship, Lordship. At two, Lordship. If I look after bail hearing.
Much my lord, I was referring to page 29. So going by this circular issued by the police headquarters, my lord, the entire responsibility of making selection
is on the committee member.
And I am nobody, my lord. I was additional SP headquarters Nagaon. My duty was totally different. Now, my lord, will kindly come to the application for 2 paragraphs, my lord. Page number 5, my lord, para 3. That the accused petitioner states that on 10/6/13, the accused petitioner has joined as additional superintendent of police headquarters Nagaon, and the duties that were assigned to the accused petitioner were that of supervision of cases, area domination, and general law and order. The accused petitioner is presently serving as Commandant 26 APIR Battalion, Kumrasali Mankasar, within the district of. Presently, I am, my lord, Superintendent of Police, Kamrup, Rural. At that, when I filed the petition, I was, my lord, Commandant 26 APBN. And in his long service career, accused petitioner had always served with utmost sincerity and dedication to the satisfaction of all concerned without any complaint whatsoever from any quarter. That the accused petitioner further states that on 24/11/12/14, an advertisement for so-and-so number of posts were advertised for recruitment of armed branch constable in Assam Police. On 25/3/15, physical tests in connection with armed branch constables were held in different venues at Nagaon Playground of 9th APVN Berhampur and Police Parade Ground Nagaon. The candidates who qualified in the physical test are directed to appear in the written test to be held on so and so. Further, Additional Director General of Police, Assam and Chairman of the State Level Recruitment Board, while later dated, informed the Superintendent of Police of various districts in the Assam that a district level selection committee had been constituted to conduct all tests and other processes in connection with recruitment for 6748 post of armed branch constable in Assam Police. Accused petitioner states that in the aforesaid letter, name of the Nagaon district appears as serial number 18. Superintendent of Police Nagaon was the chairman. Commandant 9 APBN and senior medical officers were made members of the Nagaon district level selection committee. Further, it was made very clear in the letter dated 24/12/14 that detailed guidelines, including detailed scheme for awarding marks, will be sent, and district level selection committee will be fully responsible for implementation of the said guidelines in letter and spirit. The state level police recruitment board will approve the select list of candidates for appointment as per the existing rules and after completion of all tests. The papers and digital records will remain in the custody of Superintendent of Police, concerned district. The equipments and computer hardware, etc., procured and used during process will remain in the custody of the concerned Superintendent of Police under proper inventory. Further, the Range Inspector General of Police, Deputy Inspector General of Police will also be co-opted member of the state level recruitment board within the range and will ensure proper implementation of the rules and guidelines. And due to such mechanism, it became highly improbable for anyone to conspire and manipulate the records by abusing their official position for wrongful gain in the process of the recruitment of the armed branch constable. So, my lord, this is our pleadings. Now, my lord, the state had filed an affidavit. I'll have your lordship's kind attention to para 8.
Now this.
Yes, page 5, para 8. Has your lordship got it?
Yes.
That the grounds enumerated by the petitioner in the said petition seeking quashing of the affair registered at Vigilance and ACBPS case number so and so are flimsy and cannot be sustained in the scrutiny of law, and the state of Assam strongly opposed the same on the following amongst other grounds. For that, after discreet and confidential inquiry conducted by Sri Karuna Bordoloi, APS Deputy Superintendent of Police, Vigilance and Anti-Corruption, submitted his finding as Sri Hitesh Chandra Roy, additional aspirant, was the leader of the collection group and had collected huge amount of money from 100 to 150 members of candidate at the rate of rupees so and so from each candidate. Again, in the report submitted by the chairman of the SIT, after conducting regular inquiry, it was found that 15 number of police official personnel, including present petitioner, involved in large-scale malpractice that occurred during the recruitment process of AB Constable in the Dhubri, Nagaon and Borkota district. He also stated in his report that the allegation of large-scale malpractice is prima facie and proved beyond any reasonable doubt in the recruitment process in respect of Nagaon, Dhubri and Borkota district. The chairman SIT in his report hereby recommended names of 15 number of police officials, personnel including Hitesh Chandra Roy, the present petitioner, for registering a case against those officials under proper sections of law. Hence, the contention that there is no allegation evidence showing his direct involvement in the case is baseless and has no legs to stand in the eye of law. Then my lord will kindly come to 3. For that involvement of accused petitioner, the then Additional Superintendent of Police Nagaon is in large-scale malpractice during recruitment process of constable has been reflected in both reports submitted after conducting district inquiry and regular inquiry. Government also duly accorded approval to the proposal for registration of a case after considering all the material evidence of the court. Hence, interference of this court is uncalled for. For that, the accused petitioner was marked as the leader of collection group who had collected a huge amount of money from 100 to 150 number of candidates at the rate of so-and-so from each candidate, as per the report submitted by Corona Bordloy after completion of discrete and confidential inquiry. His involvement was also reflected in the report submitted by Binoy Kolita, Chairman SIT, after completion of the regular inquiry. Involvement of Aurobindo Kolita, APS Chairman, District Level Selection Committee, Nagaon in such malpractice was not reflected in any of the report submitted after conducting discrete inquiry, and regularly, hence no criminal case was registered against Chairman. Now, my lord will kindly come to page number 8. Kindly see, my lord, para 10. That the statement made in para amongst others 8 are true to my knowledge. That means, my lord, this particular para 8 has been verified as true to the knowledge of the, my lord, deponent. Now, what is the source of knowledge? You must declare. Well, end of the day, you are taking a stand on behalf of the state where you want to set in motion a criminal law. I am saying there are no materials. You are saying there are materials. You have every right to take that stand. But my lord, this has to be not based on any subjective satisfaction. Now, kindly see this statement, my lord, on the end of the day, we are to go by their affidavit. Why they feel so? Because the Corona Bordloy's inquiry reveals after completion of discrete and confidential inquiry. I could have appreciated some aggrieved candidate who took part in the selection process, who was not selected because of some wrongdoing by some people. There are 161 statements were taken. Or some statement, say 161 statement of somebody else are taken. Now, this Corona Bordloy, now and the informant is one Mr. Mitra. Now, on what basis we have said so? Can criminal law be set into motion merely on the basis of subjective satisfaction of an investigating officer? Was it not in end of the day, we have no access to the case diary. So in your affidavit, you must specify the materials which state, proposes
Now,
to rely upon.
whether case diary has been called for in this.
It was called for.
It is there before the court. Case diary.
No, but President, it is not available with me, my lord. My lord, in the next step, my lord, I will, if it is available in our office, my lord, I will certainly protect.
Because perusal of the case diary.
Of course, my lord. That I cannot say no. Now, my lord, let us take the case of section 227 or 228 of CRP. Now, one deals with when charge is to be framed. One deals with, my lord, when charge should not be framed. Now, my lord, the Supreme Court has said the probative value of the materials has to be taken note of. Yes, at this stage of, my lord, framing of a charge, my humble understanding of criminal jurisprudence is, my lord, the test would be slightly more than prima facie case. That's why Supreme Court says, because when Lordship tests an FIR, Lordship goes by the mere statement made in the FIR. At the stage of granting bail and all, Lordship will not go by the probative value of the statement. But at the stage of framing of the charge, some of the judgments Supreme Court says the test has to be slightly rigorous than what test Lordship adopts at the time of enlarging a person on bail based on the allegation made in the FIR. Now, my lord, this discrete and confidential inquiry, how can those be the basis for setting in motion a criminal law, my lord? What would be the probative value of that subjective satisfaction of the IO? Had it been a case where many aggrieved persons, my lord, complained before the authority that in this process XYZ anomalies were committed, XYZ are responsible for this, and then that's a case where it's a prima facie case is there. At least, my lord, the person against whom the allegations are made, they should stand the trial. But, my lord, when you want somebody to stand a trial, is it not necessary for on their part to bring some more material? I can appreciate, my lord, FIR may not contain anything, everything. Even after filing of the FIR, you can collect materials.
But you are praying for quashing of the
No,
FIR.
that's why, my lord. Now, in the affidavit, were they not looking down to produce the, materials, my lord? In the affidavit, my lord, they had a duty to say so. Otherwise, my lord, how do we know what the CD contains, what materials, on what materials they have proceeded? First, my lord will kindly see.
But there are allegations against you in the FIR.
No, those are in the realm of ifs and buts, not allegation. These are the
Accusation is there. In
no, no, my lord. I'll respectfully submit. Allegation, my lord, also stands on a slightly higher footing. Then, my lord, based on which they have filed the registered the case. They say they have made some discreet and confidential inquiry. From discreet and confidential inquiry, they could come to learn that some people were involved in collection of money as a quid pro quo for job. Now, those materials must have some probative value. What are those? If it inspires your lordship confidence, certainly lordship will not allow my petition. If it does not inspire your lordship's confidence, that's why in Pepsi Food Products case, Supreme Court says, merely because, my lord, person can be discharged at this, stage of trial, that does not mean, my lord, he should face the trial. If we can make out, it's not that, my lord, quashing an FIR is a concept which is not envisaged in law. It is envisaged in an appropriate case. Of course, in the rare of the rare case. If I can satisfy your lordship that here is a case there is absolutely no material. Why I'm saying so, lordship will kindly appreciate.
No, when FIR may be quashed.
FIR may be quashed when it does not disclose, not only on one ground, Bhajanlal's case, starting from Bhajanlal's case, there are, my lord, several grounds are there. But it can't be on the mere ipsy-dixit of somebody. There must be some material which must inspire the confidence of people. My lord, I have not said that Honorable Supreme Court said in so many cases. The question is, he was setting criminal law into motion. I am a responsible person. I am not involved in this. Why people will come and pay me, my lord, for at the first instance? Who am I? Therefore, I am saying, my lord, unless my actions, I conspired with the 3 persons in that committee, my lord, I cannot do any favor to anybody. But that is not the allegation. How they independently prove my involvement, my lord? I am saying so, my lord. If I can be let off, why should I face the ordeal of a trial? Why should I face the ordeal of a criminal investigation? Because I'm a government servant. I kindly appreciate, my lord. In the scheme of this election, number one, I do not have any role. Unless the 3 members conspire with this 15%, nothing can happen. But that's not the allegation. How do they establish their case? My lord, a prosecution cannot, my lord, it cannot hold water, my lord. It cannot stay in thin air.
The allegation against you is that you...
I am involved in collection of money.
Yes. So your submission is money can be collected only by committee members,
not by committee. End of the day, my lord, supposing, my lord, the allegation is correct. What is the allegation? Some candidate has paid money to me. Paying money to me will not do anything unless, my lord, the committee members are also part of that trial. I cannot give job. I'm not the signatory. I cannot say that so and so is selected.
But you can promise that I will give you job.
That's not the allegation. That's not the allegation. Their Bhajanlal will come into play, my lord, with full force. That's not their allegation. They vaguely say that I was responsible for collection of money along with some others. Now, my humble submission is, my lord, why people will come and pay me unless I am in a position to deliver? So, therefore, that's what I'm saying, my lord. The allegations must have some probative value. And to form that opinion that I am guilty of some wrongdoing, which attracts a criminal offense, my lord, I think the material has to be credible. Mere discreet and confidential inquiry based on that you cannot. Yes, I could have appreciated, my lord, some 161 statements are recorded from some candidates who have paid yet they did not get the job and naming XYZ. But therefore, Lordship may like to have a look at the case diary. That's not my case either. But my lord, to say that I'm guilty based merely on the basis of subjective satisfaction of this Corona Bodle, I think that will be too much. If there are materials, certainly Lordship will not quash this proceeding. But my humble submission is, my lord, if you are to set the criminal law in motion as they're trying to do, my lord, then my lord, there has to be some material, some statement of some, my lord, person who are aggrieved, or some responsible person saying yes, merely because they suspect, merely because they feel discreet and confidential influence. I think, my lord, when it comes to, my lord, collecting information, those may be a relevant consideration. But when it comes to, my lord, setting the criminal law in motion, I don't think, my lord, discreet or confidential inquiry can come to the aid of this state.
Whether any interim.
Yes. The
really
proceeding
was-
is state, my lord.
Oh. So there is no investigation.
No.
So whatever material is there, it is at.
No, my lord will test because they have set the criminal law. Now, therefore, Lordship will test the materials, whether that could
Available material.
material available that they could have. I'm not even on the registration of the case, my lord. Whether they could have proceeded. Maybe against somebody there are some materials. I do not know. There are 16 other.
Whether against you materials are there on.
Yes.
In the discrete.
Yes. Whether the materials are good enough, at least to make me stand the track. That satisfaction Lordship can arrive at having a look at the material.
When you approach after how many days after
Even
registration?
My lord, it's a long matter, my lord. It's a criminal petition of 16.
So whether any state.
I think, my lord, interim order was given on 4/11/16. And FIR is dated.
Registered on.
FIR is dated 13th of June 2016.
So 5 months of investigation was.
Yes. And I approached this honorable court on. In fact, the notice was issued on 4/11/2016.
So suppose within this June to November.
Yes.
There
Let
is
us
some
see what materials they
investigation.
have gathered against.
If there are materials collected within this period.
Yes.
Then.
No. If
I can go through.
Certainly.
Okay.
Certainly. All that I am saying is merely because somebody suspects that there is some wrongdoing, that is not enough. That's what I said. I was trying to bring that test which is normally applied when the charges are framed. Materials which has got some probability.
For when charges are framed, you are supplied the copies of the
everything.
But this
No,
is not that stage.
Even now, my lord, at least the prima facie case has to be there. Now, for example, my lord, there is no statement of any aggrieved person. Now, they are only relying on some discrete information. Somebody is saying somewhere, hearsay thing. Will that be enough?
There has to be some record of discrete inquiry.
That is in my humble submission, my lord. At least their affidavit do not disclose. We can't be privy to their records, my lord. We can be made aware of the stand of the authority only by an affidavit.
161 statements have to be there.
Exactly. And they have filed their affidavit. Affidavit does not disclose anything. So we are to go by the affidavit. And affidavit was filed on, my lord, kindly see the date, is 17/11/17. To that we filed our reply. My lord, what I propose to do, my lord, let my learned friend make his submission. Then I'll give a short reply. Then on that day, I'll place the case clause also, my lord. Basically, this is my case.
When will you?
My lord, next week, my lord, and if my lord, as lordship observed, my lord, the case, any record, my lord, of that 4 months, my lord, that maybe, my lord, called.
No,
It was
that
called
will be
collision,
there
my
in
lord,
the.
quoted.
that
It was
will be
called for, my lord.
Not received today, my lord, again, I have to.
Oh. I think matter
No,
can be taken.
because if the investigation has already been stayed.
Yes, my lord.
In November.
Yes.
So 4 months they had, my lord.
But-
Four, in fact, 5 months.
In the year 2016 itself,
Yes.
then the case diary should have been with the case record. By
No,
now,
case diary was called for, my lord, but it was not submitted. In fact, on
Maybe.
2, 3 occasions, I think this honorable court to dispose of the matter called for the case diary. In fact, I think on my lord, I think
Then
28/8/23 also an order was passed. Original CD called along with the report of SIT. Even 28/8/23 there is an order.
okay. Therefore, I asked whether to proceed with the hearing because unless we get the case diary,
Anyway, my lord, lordship has heard me today. My learned friend can have a date in the next week. My lord.
when will you produce?
Next Friday, correct?
Next Friday, my lord, in next week, Friday, my lord, it will be,
26 तारीख को.
it is 24, my lord.
Heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. E. Deuri for the petitioner. Also heard Mr. B. Sharma, Learned Additional Public Prosecutor. The hearing remain inconclusive. In the meanwhile, Learned Additional Public Prosecutor seeks some more time for production of the case diary along with the SIT report. Along with the SIT report. The prayer of the Learned Additional Public Prosecutor is allowed. The hearing remained inconclusive. Let this matter be listed again on 24.
My
lord,
24/11.
April.
Hearing B, item number 25.
May I please tell us? 49 application losses, 76 days in custody, 302 citation losses. Okay, no cleansing losses. To my instruction losses, the petitioner before losses has not participated in the cleansing losses. The two petitioners before losses. In the affair, so many accused persons are mentioned in the affair losses.
Where is the affair?
Case 8 losses.
What is the allegation?
What is the allegation? Is made in the affair losses, case 9 losses. Particular affair
His case diary is there.
Yes, is there.
How many days he is behind the bar?
76 days.
The injury is grievous.
No, my lord, 302.
Or 302. What is the progress? Materials would be there.
Yes, my lord, the material is there against this person, my lord. He was present, my lord. Only one thing, my lord, that
Whether he assaulted.
assaulted. Yes, with
He
cookery.
assaulted.
Yes, yes. He along with some other persons also.
No.
That material is there, my lord. Only that 76 days.
And what is the progress? At what stage?
Now, last, my lord, it is postmortem already collected, my lord. That almost, my lord, last is ready for filing. That's it. Only some person yet to be, my lord, apprehend, that is.
that person, my lord, deceased, my lord.
No, there are 11 accused persons.
Yes, yes,
Out of these 11, who is on?
yes, my lord. All are yet not apprehended by the list, my lord.
Against the present petitioner.
Yes.
Who are the petitioner? Jonti
Two person.
Sangmai and
Junti Sangmai, Bipusan. Name.
Jonti and people. Against them, specific allegations are there on.
Yes, yes, yes.
It is there.
Yes.
Can
Other person
the movement thing was the deceased person was suffering from the psychiatric patient.
Yes, yes, yes.
He created some havoc. And the present prisoner tried to stop the deceased person. And some other person has assaulted. And they are the present they are trying to stop the state assault. That's my instruction. Save the lawsuit. The deceased from the assault of lawsuit. The informant lawsuit.
Mentally retarded person, my lord, he may.
What is your name?
My name is Lawsuit, the present Janti Sangmai and Bipul Sangmai.
Bipul and
Junti Law.
Bipul and
3 and 5 in the FIR.
as per the FIR, one Jivan Sangma has assaulted the accused number 1. As per the FIR.
বাকি কেজন আছে জীবনও আছে
Jivan is the main person. Okay.
প্রিয়ামাইসি বিপুল
Jivan.
বিপুল
What is your submission?
My submission will be, my lord, material is there. If lordship will consider on the length of detention, I leave it to lordship. Otherwise, material is there.
No, whether state wants them to be detained or
Otherwise, 90 days offense.
So the FIR mentioned that one Jivan Sangmai he yet to be arrested, but he has assaulted first Jivan Sangmai. Accused number 1 for the FIR. Mr. T. Sutia, learned counsel for the petitioner. Also heard Mr. B. B. Gogoi, and additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Jonti Sangmai and Bipul Sangmai, who are detained behind the bar since 2nd of September 2023, within bracket, since last 76 days, in connection with MRGPS case number 126/23. The gist of accusation against the present petitioners is that on 1st of September 2023, one Srimati Renu Gogoi had lodged an FIR before the officer in charge of Dhemaji police station, inter alia, alleging that on 31/8/2023, when the husband of the first informant was going to the shop to purchase some edible items, the accused persons named in the FIR, within bracket 12 accused persons are named in the FIR, bracket close, had assaulted her husband. It has been specifically mentioned, alleged in the FIR, that one Jiban Sangmai assaulted the husband of the informant with an iron rod, as a result of which he fell down on the ground, and thereafter the accused persons assaulted him with dao and other weapons. So it is further stated in the FIR that later on the husband of the FIR was taken to Dibrugarh in husband of the first informant succumbed to his injuries on his way to Dibrugarh Medical College Hospital. Learned counsel for the petitioner has submitted that the husband of the first informant was mentally ill person, and he was being assaulted by general public, and the present petitioner went there only to help the petitioner only to save the petitioner from the assault of general public. It is also submitted by learned counsel for the petitioner that in the FIR specific allegations are made against one Jibon Sangmai, who is still absconding, and no such specific allegations are there against the present petitioner. Further, learned counsel for the petitioner has also submitted that, considering the period of detention already undergone by the present petitioner, they may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Dhemaji PS case number 126/2023 and has submitted that there are incriminating materials in the case diary against the present petition. However, he has also submitted that the investigation in the meanwhile, has fairly progressed. Why it is pending?
Some of the co-accused yet to be apprehended.
And it is pending because some of the co-accused persons are yet to be apprehended. Stop. I have considered the submissions made by learned counsel for the petitioner as well, learned counsel for both the sides, and have gone through the case diary of the Dhemaji PS case number 126/2023. On perusal of the FIR, it appears that specific allegations are made, though the present petitioners are named in the FIR. However, specific allegations are made against Jibon Sangmai. It also appears in the on perusal of the case diary that though there are some incriminating material in the case diary against the present petitioner. However, considering the progress made in the investigation as well as considering the fact that the petitioners are already detained behind the bar since last 76 days, their further custodial detention does not appear to be necessary for fair completion of the investigation. If stop. In view of above, the above named petitioners, namely Janti Sangmai and Bipul Sangmai, are hereby allowed to go on bail of rupees 50,000 each, with one surety of like amount subject to satisfaction of learned Chief Judicial Magistrate Themaji, with following conditions. Number one, that they shall cooperate with the investigating officer and shall appear before the investigating officer as and when so required by the investigating officer during the pendency of the investigation. Stop. They shall not directly or indirectly make any inducement, threat, or promise to the first informant or to any other person who may be acquainted with the facts of the case, so as to dissuade such person from disclosing such facts to the investigating officer or to any court. Stop. Number three, they shall not indulge in any offense similar to the offense of which they are accused in this case. With above observation, this bail application is disposed of.
I would like to
send back the case.
Item number 26.
Dear Lordship, charge sheet submit.
It's 76.
Heard Mr. H. A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. B. Gogoi, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, the investigating officer has laid the charge sheet. Stop. In view of laying of the charge sheet, this bail application is disposed of with an observation that the petitioner may approach learned trial court and may pay for regular bail before learned trial court, if so advised.
All right.
Item number 27.
The 439 application made petitioner is facing trial under section 370.
370.
370. The victim he has been examined thereafter on 9 occasion PW nor appeared to the case. But we will find the FIR.
When were you arrested?
Arrested on my lord 19/4/2023. Lot will find at page 19.
Since how many days you are behind the bar?
I am behind the bar for last 221 days, 7 months.
Yes.
Lot will find the FIR page 12.
The case, when the charges were framed?
Same, my lord, and PW1, that is victim examined already.
Yes,
Victim has been examined.
Yes.
Then why trial court is not have rejected your bail?
My lord, on that earlier petitioner rejected that because the victim was not examined.
Thereafter?
Thereafter, it says that the minor son, though it was not a cited witness, he may be examined. He was summoned as the court witness.
Okay.
And on 9th occasion, my lord, steady element, no witness has been turned up.
When the victim was examined?
Yes, on 28th of April, my lord. Lordship will find at page 37, page 27, 2020.
In the record, I have flag mark it.
What is your name?
I am Safiyul Tufail
Safiyul.
Ahmed. Tufailuddin.
Sufailuddin.
Tufailuddin. My prayer, my lord, only, my lord, since the last night occasion, no prosecution witnesses turned up. The trial may take time, my lord. I'm in custody for last.
How many listed witnesses are there?
There are 8 listed witnesses, my lord. That will find at page. Yes.
8.
And where is your permanent residence?
That looking for, my lord, I'm a resident of.
Now, what assurance you will give that you will face trial?
Well, any condition looking may be.
What condition?
In any condition, I'll face the trial. I'm a local resident of Lakhimpur, my lord, resident of number 2 Tiju Kothar, Post Office Tiju, PS Lakhimpur.
Okay, heard Mr. P. Hajurika, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Muhammad Sufail Uddin, who has been detained behind the bar since 24/2023, within brackets since last 221 days, in connection with, what is the sessions?
Session case number you will find at page 2, my lord.
In connection with session case number
114
within
within bracket
bracket NL/2023, corresponding to North Lakhimpur Police Station case number 858/21. Learned counsel for the petitioner has submitted that based on an FIR lodged by one Rahima Begum on 26/7/2021, an investigation was initiated, and after completion of investigation, charge sheet was laid against the present petitioner under section 370, only 370,
Only 370.
370 of the Indian Penal Code.
Custody were laid on 26/7/2020.
On 26/7/2020.
Sorry, 26/4.
26/4/2020. It is also submitted by learned counsel for the petitioner that the petitioner was, when were you arrested?
I was arrested on 19/4 prior to that.
during the investigation.
Yes, sir. Page 19.
That during the course of investigation, the present petitioner was arrested on 19/4/2023. It is also submitted by learned counsel for the petitioner that the charges were framed against the present petitioner on which date?
My lord. Yes, my lord.
Charges were framed against the present petitioner under section 370 of the Indian Penal Code or
Yes, so bringing a charge I have concerned, my lord. That is prior to June 2023. But the 6/7/2023, page 33.
on 6/7/2023. And the victim was examined at PW1 on 27/2020. Thereafter, 9 dates for prosecution witnesses were fixed by the learned trial court. However, the prosecution side has failed to bring any further witnesses, and the prosecution has and the trial has not progressed beyond examination of the PW1. Learned counsel for the petitioner has also submitted that there are total 8 witnesses listed in the charge sheet, 8 prosecution witnesses listed in the charge sheet, and considering the current pace of the trial, the completion of the trial would take a considerable period of time, and therefore the petitioner has learned counsel for the petitioner has prayed for allowing the petitioner to go on bail. It is further submitted that the petitioner would cooperate in his trial if he is allowed to go on bail. What is your opposing the bail, or you have no?
My objection may be recorded, my lord.
On the learned counsel for learned additional public prosecutor, on the other hand, oppose the grant of bail to the present petitioner on the ground that the offense involved in this case is serious in nature and only one prosecution witness has been examined. It is further submitted that the son of the victim, who is a minor, has been summoned by the learned trial court as court witness, and he may have to be examined. And if the petitioner is released at this stage, there is a possibility of petitioner threatening the son of the present witness. I have son of the PW1. I have considered the submissions made by learned counsel for the both sides and have perused the scanned copy of the case record of session case number 114 within bracket NS /2023. It appears from the record that it appears from the submissions made by learned counsel for the petitioner as well as on perusal of the records that the petitioner has been languishing behind the bar since last 221 days and only one witness has been examined. It also appears that the sole witness who has been examined happens to be the victim in this case. It further appears It further appears that the petitioner is a permanent resident of Deju Kothar, of
Number two,
village
Deju
village number 2, Deju Kothar, under Lakhimpur police station. And considering the fact that the trial has not progressed any further since last 9 days, and considering the long period of detention of the present petitioner, this court is of considered opinion that further custodial detention of the present petitioner may not be justified if he otherwise cooperates in the trial. So, in view of above, the petitioner Sufailuddin is allowed to go on bail of 50,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate.
The trial is in
Sorry,
additional session judgment.
learned additional session judge within bracket FTC Lakhimpur, with following conditions: that the petitioner shall cooperate in his trial and shall appear before the trial court as and when so required by the learned trial court. The petitioner shall not directly or indirectly subject any of the witnesses or any other person who may be acquainted with the facts of the case so as to dissuade such person from deposing against him in the pending trial. Stop. Number 3, learned trial court may impose any additional condition if it deems fit to do so before allowing the accused person to go on bail. With above observation, this bail application is hereby disposed of. Send back the case.
Public.
May I please the Lordship? Lordship, in this case, the accused charged with section 366 and he has been behind bars since 2012. FIR is in page 11.
This is a charge sheeted case.
Charge sheeted case, LCR, scan copy of LCR was called for, that is received, my lord. A case is of, my lord, production stage. Charge it to be framed.
Yes.
Lordship, in page number 12 FIR, if you see, here the complainant accepts to the fact that we have a doubt that some kind of relationship is there between them, but still the girl is very young and there is complete possibility that after kidnapping the girl, Sri Rahul Marman might commit any crime with the girl or he might try to outrage the modesty of the girl. So here, my lordship, there is a landmark judgment by the apex court whereby the apex court states that section 366 IPC would come into play only where there is a forceful compulsion of marriage by kidnapping or by inducing a woman.
Now charge sheet has been filed against you. You may take this plea before the trial court at the
time of framing charge.
Now the question is now whether his detention is required.
My lord,
the only
victim girl, my lord.
You may influence the victim girl. That is the agreement.
Victim girl statement has been recorded.
No,
That
trial
is
has not
164.
yet started.
That is 164.
Before she deposes against you as a
Any
prosecutor.
condition may be imposed.
Where is 164 statement is there?
That is, I think I have, that is in the record.
NCR.
Not absent. 164.
Or Mr. Gogoi, you go through 164
My
statement.
lord, my lord.
After lunch, we will also have Mr. B.B. Gogoi and an additional public prosecutor. This application under section 439 of the Code of Criminal Procedure from 1973 has been filed by the petitioner Rahul Burman, who has been detained behind the bar since 28/7/2023, within bracket since last 112 days, in connection with what is the in connection with sessions case number 188/2023 under section 366 of the Indian Penal Code, corresponding to Hatigao PS case number 250/2023, pending before the Court of
Additional Judge 4.
Learned Additional Session Judge number 4, Kamrup Metropolitan, Guwahati. Learned Counsel for the petitioner has submitted that the petitioner was arrested on 28/7/2023 in pursuant in connection with Hatigao PS case number 250/2023, which was registered on the basis of an FIR. Where is the FIR?
Page 11.
FIR
Valid.
FIR lodged by one
Lalit.
Srimati Lalita
Lalita.
Kolita on 28/7/2023 before the officer in charge of Hatigao Police Station, inter alia, alleging that her daughter
Niece.
was abducted by the, you have been named, na?
Yes, yes.
Yes,
ma'am.
Lordship.
Abducted by the present petitioner. Stop.
Lordship, the victim is not her daughter. It's her sister-in-law's niece.
Her sister-in-law's niece has been abducted by the present petitioner. Stop. After completion of the investigation, charge sheet has been laid. You have furnished a copy.
Yes, Lordship.
At
Page number
which
25.
charge sheet has been laid against the present petitioner under section 366 of the Indian Penal Code. Charge sheet has been laid against you only, no?
Yes, Lordship.
366 of the Indian Penal Code. When charge sheet has been laid?
If the sheet has been submitted on 15/8/2023 on page 26.
And when case has been committed?
Case has been committed on 28/7/2020.
Learned counsel for the petitioner has also submitted that though the case has been committed to the court of learned additional sessions judge to the sessions court on 28/7/2023, however, and several dates have lapsed since then. However, the charges are yet charges to and charge against present petitioner has been framed. However, no witnesses have yet been examined. Learned counsel for the petitioner has submitted that the petitioner is a permanent resident of Patharkusi under Procedural Police Station within the jurisdiction of the trial court, and it is submitted that the petitioner would face the trial if he is allowed to go on bail. Stop. I have perused the scanned copy of the sessions, scanned copy of the case record of sessions case number 188/2023, and have also perused the statement of victim girl recorded under section 164 and section 161 of the Code of Criminal Procedure. It appears from the statement of the victim girl that though she was minor at the time when the alleged offense was committed, she had love affairs with the present petitioner and had herself accompanied the present petitioner. So be that as it may, as the trial is pending and the petitioner has been detained behind the bar since last 112 days and is willing to face trial, this court finds no justification in keeping the present petitioner under detention, in continuing in allowing the present petitioner to remain under detention during the pendency of the trial, if he otherwise cooperates in the trial. So, in view of above, the petitioner Rahul Burman is hereby allowed to go on bail of ₹30,000 with one surety of like amount to the satisfaction of learned additional sessions judge number 4, Kamrup Metro, Guwahati, with following condition that number 1, that the petitioner shall regularly appear before the learned trial court as and when so required by learned trial court and shall cooperate in his trial. Number 2, that the petitioner shall not directly or indirectly make any inducement, threat, or promise to any of the witnesses or any other person who may be acquainted with the facts of the case, so as to dissuade such person to depose against him in the trial pending before the learned trial, in the trial of sessions case number 188/2023 before the Court of Learned Additional Session Judge number 4, Kamrup Metro, Guwahati. With above observation, this bail application is thereby disposed of.
For 489.
May I please? My lord, this is 439 application, my lord. I am behind the bar since 42 days, my lord. FI is page number 8. Some Indian fake currency were recovered from my possession. That is
Yes,
the
there is
allegation.
that.
Yes, very received. Perhaps section 489C will come, my lord. That is 7 years imprisonment, 60 days mandatory. Otherwise, case is registered under section 489A, 489B, 489C, 489D.
489 a life, my lord. 90 days offense.
Perhaps 489C will come.
A only.
C is possession.
My lord, possession. And those were recovered from my possession. So far as the FIR.
Otherwise, witnesses have been recorded.
Yes, yes, my lord, that it was seized from his possession, my lord. And he also admitted.
Perhaps substantially progress the industry. Further capital for sales or buying, my lord. Deals with sales. 489A, my lord. Counterfeiting currency notes or bank notes, whoever counterfeits or knowingly performs any part of the process of counterfeiting any currency note or bank note shall be punished with imprisonment for life or with imprisonment of further detention for term which may extend to 10. 489A will not. Those are recovered from my possession.
Heard Mr. A. Paramanik, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioners Anwar Rahman, who has been detained behind the bar since 6/10/2023, within bracket, since last 42 days, in connection with Boko PS case number 475/23 under section 489A/489B/489C/489D. The gist of accusation against the present petitioner, in this case, is that on 6/10/2023, one Julie Das, SI of police of Somaria Police Outpost, lodged an FIR before the officer in charge of Boko Police Station, inter alia, alleging that on receipt of and secret information through reliable source, a Naka checking was organized in front of the Dilbar Ali's garage at Kalatoli Bazaar. And during Naka checking, the present petitioner was apprehended and was found in possession of fake Indian currency notes. Learned counsel for the petitioner has submitted that though. What is your submission? These
My
are.
lord, I am nowhere connected with this case. My lord, actually, those currency was not recovered from me. It was recovered from the backside of Dilbar Ali's garage.
Caesar list is there, my lord.
And I am
This
totally-
161 statement.
I
your
am
lordship
totally
appears.
innocent. I am totally innocent. That is my complete.
learned counsel for the petitioner has submitted that the petitioner is innocent and the allegations leveled against the present petitioner in the affair is not true. It is also submitted that the recovered fake Indian currency notes were found from the backside of the Dilbar Ali's garage and not from his possession. It is further submitted that even if it is assumed that the fake Indian currency notes were found from his possession, only section 489 C would be applicable, for which the maximum statutory period of detention is 60 days. It is further submitted that the petitioner has already been detained behind the bar since last 42 days. And on that ground, the prayer for bail is made. On the other hand, learned additional public prosecutor has placed the case diary of Boko PS case number 475/23, which was called for in connection with this case, and has submitted that there are sufficient materials in the case diary to show that fake Indian currency notes were found from the possession of the present petitioner. So, I have heard learned counsel for both the sides and perused the case diary, which was called for in connection with this case. On perusal of the case diary, it appears that though there are incriminating materials in the case diary to show that the fake Indian currency notes were found from the possession of the present petitioner. However, it also appears that in the meanwhile, investigating officer has recorded the statement of witnesses and the fake Indian currency notes were also seized. And it appears that there is a fair progress made in the investigation. Stop. Considering the fact that the investigation has fairly progressed, also considering the fact that the petitioner has already been detained behind the bar since last 42 days, this court is of considered opinion that his further custodial detention may not be necessary if he cooperates in the investigation. In view of above, the petitioner, namely Sanwar Rahman, is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of Judicial Magistrate First Class, Boko. With above observation, this bail application is for the send back the case diary.
Item number 30.
Mayor, please, your Lordship.
3013.
Here in this case, my lord, I have been shown arrested on 12/10/2023, my lord. As such, I am behind the bar since 36 days, my lord. Initially, I was arrested in connection with Sonapur PS case number. In that case, already bail has been granted, my lord. Page number 16, my lord.
What is the allegation?
Allegation is that, my lord, some mobile equipments have been stolen away from Gorsuk side, but nothing has been recovered. The FIR was lost on 8/8/2022. My lord, while I was inside the jail, the investigation agencies don't arrest me in the instance. Nothing recovered from my possession, my lord. The incident happened in the year 2022, 8/8/2022.
8/8/2022. Is there any
diary received, my lord? Is a, my lord, owner of scrap materials
vendor?
My lord,
he is owner of?
scrap material vendor, my lord.
Okay.
So earlier he purchased some goods, my lord. So police suspect that he might be, my lord, connected with the case. But his 161 statement says that I am not connected with present case.
Otherwise,
Moreover, my lord, from one Borua, earlier he purchased some goods, my lord. That Borua's statement is not here in the diary, my lord.
No, but the allegation is also of habitual dealing with stolen
My lord.
property.
Normally, I am scrap materials vendor. Each and every day, some person comes, I purchase, but I did not purchase no materials recovered in the instant case. That's because the incident occurred in the year 2022. After 1.5 years, I have been arrested in this case. Shown arrested.
Heard Mr. A. Paramanik, learned counsel for the petitioner, also heard Mr. B.B. Goboi, learned additional. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Abdul Khaleh, who has been apprehended, who has been detained behind the bar
36 days.
since
12
no,
10.
no. In earlier case, when you were
210, my lord, 210.
detained behind the bar, in this case, no, detained behind the bar, who has been shown arrested in connection with shown arrested on 12/10/2023 in connection with Gorsuk case number 239/2022 under section 411/413/34 of the Indian Penal Code. The acquisition in this case is that on
Page number 12, original affair.
which is the what's the date? Date of affair?
My lord, 8/8/22.
On 8/8/22, one Hirokjyoti Bejgurua had lodged an FIR before the officer in charge of Gorsuk police station, inter alia alleging that some of the tower assets were stolen by, as some of the tower assets, as mentioned in the FIR, were stolen by some unknown person from ATC site near Gorsuk, near ISBT stop. Learned counsel for the petitioner has submitted that with
Sonapur PS case number 208/23.
Sonapur PS case number 208/2023 on 2/8/2023, and while he was in custody in connection with that case, he has been shown arrest in connection with the instant case. However, he is not in any manner involved in the offense alleged in the FIR dated 8/8/22. It is further submitted by learned counsel for the petitioner that though the FIR is dated 8/8/22, however, he has been shown arrest after 1 year, 2 months in connection with the said case, and nothing has been recovered from his possession. On the other hand, an additional public prosecutor has placed the case diary, has produced the case diary of Gorsuk case number 239/2022 and has submitted that the petitioner is a scrap material vendor and earlier there were instances of him purchasing these stolen goods. And some of the witnesses are yet to be examined. So I have considered the submissions made by learned counsel for both the sides and have perused the case diary of Borsuk PS case number 239/2023. On perusal of the case diary, it appears that the petitioner has been arrested on the basis of his past conduct and on the basis of suspicion. However, at this stage of the investigation, there is no material in the case diary against him to justify his further detention. Further, the petitioner has already been detained behind the bar since last 36 days, and hence his further detention does not appear to be necessary if he cooperates with the investigating officer in the investigation. In view of above, the petitioner Abdul Khaled is hereby allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Kamrup Metro. With above observation, this bail application is disposed of. Send back the case.
Highly obliged.
Well, the diary is not available on two occasions. On the face of the record, my lord, my lord, the lady and this accused, my lord, with all respect, my lord, she has implicated affair is at case 10, my lord.
No, but perusal of diary would be.
Yes, my lord. Can it be, my lord, 2 days it is not come, my lord. Can it be on Monday? Am I?
Mr. Gogoi, when can diary be?
Belfort, my lord, 29.
Heard Mr. B.K. Mahajan.
বন্ধ থাকিলে 3 দিন।
Heard Mr. B.K. Mahajan, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi. How early it can be?
Then 23rd, my lord.
My lord.
Heard Mr. B.K. Mahajan, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor, who submits that though the case diary was called for, however, same has not arrived, and prays for some more time for producing the same. If prayer is allowed, let this matter be listed on 23rd 11.
My lord. Can it be positively, my lord, definitely. My lord.
More note this last chance.
Highly obliged.
Item number
Worship, 439 bail application worship. Affair is 11. The petitioner is behind the bar for 33 days. Allegation under section 306. As per FIR lordship, there is no allegation in the present petition.
Who are you?
I am the case number 1 lordship.
How you are connected?
Who died?
Yeah, neighbor lordship.
Your neighbor?
Yes.
Okay.
There is no allegation against the present petitioner lordship. Entire allegation against the wife of the petitioner and father-in-law of the petitioner. Case 11 lordship.
Husband died?
No lordship. Neighbor's son. Informant is the neighbor and his son is at about 18 years old.
Okay.
You jump in the river, my lord. That is the postmortem report also drawn in.
What material is there again?
Material against this person, my lord, that is not a complainant, and some neighbor statement is there, my lord. Some main allegation is against some other person, my lord. That name is there in the diary, not against this person, my lord.
Heard Mr. S. Alam, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Nakibuddin Ahmed, who has been detained behind the bar since 16/10/2023 in connection with Baihata Sareli PS case number 215/2023 under section 306/34 of the Indian Penal Code. The gist of accusation in this case is that on 15/7/2023, one Farida Begum lodged an FIR before the officer in charge of Bahata Sarif police station that on 12/7/2023, the son of the petitioner, namely Mirazul Ali, went to the house of one Nakib Ali. Nakib, the present petitioner, went to the house of the present petitioner, and after returning back from the house of the present petitioner, the wife of the present petitioner accused him of stealing her mobile phone. It is also alleged in the affair that on the next day, one Ismail Ali had assaulted, who is the father-in-law of the present petitioner, had assaulted the son of the first informant and also mentally and physically tortured him. And because of the said mental and physical torture, the son of the first informant committed suicide by jumping into the Bornodi river. So, learned counsel for the petitioner has submitted that the petitioner has been detained behind the bar since last 33 days, and he is in no way involved in the offense alleged in the FIR. It is also submitted by learned counsel that a bare perusal of FIR would reveal that the allegation is made, that no allegation is made against the present petitioner except the fact that on 12/7/2023, the son of the first informant visited the house of the present petitioner. So, learned additional public prosecutor has produced the case diary of the Bahata Charali police station case number 215/2023 and has submitted that at this stage of investigation, there is no sufficient material against the present petitioner. Has fairly submitted that at this stage of investigation, there is no material against the present petitioner to continue his further detention. In view of above, the petitioner, namely Nakibuddin Ahmed, is thereby allowed to go on bail of 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Kamru.
Lordship, subdivisional SDGM
Wrong. Subject to the satisfaction of learned Subdivisional Judicial Magistrate within bracket F. Wrong. With above observation, this bail application is thereby disposed of. Send back the case.
Interim person. Interim. Diary not received, my lord. It is in interim.
In this case, several times, several dead gone, your lordship.
How many days?
3 days probably.
One 12.
One more. You are on interim. Let
Yes,
us,
yes. Last chance maybe.
what was the offense? 326
326 and 379.
Heard Mr. N. Padhyay, learned counsel for the petitioner. Also heard Mr. B. Gogoi, learned additional public prosecutor, who submits that though the case diary was called for, however, same has not arrived. He prays for one last chance to the prosecution side for producing the case diary. Prayer is allowed. Let
Interim
this
order.
case be listed again on 1st of December. The interim order shall continue till next day.
Acknowledged.
May please. Call for the case diary and. My lord, we have received the case diary, my lord. And after interim, my lord, he has appeared before the IO, my lord.
Heard Mr. N. Ahmed.
But my lord, one thing, my lord, that the injury report we have not received, my lord.
What was the alleged injury?
Because it is, my lord, 326 is there, my lord. Section 326 is there, my lord.
From evidence, any indication what kind of injury has?
Oh, no, my lord, the weapon, my lord, that is the mention, my lord. But
His statement has been recorded.
recorded.
Otherwise, he is cooperating.
My lord, that is.
Heard Mr. N. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Who has produced the case diary of Ajo PS case number 711/2020, which was called for in connection with this case. Learned additional public prosecutor has submitted that though the case diary has been received, however, injury report is not there. However, he has also submitted that the petitioner who was granted interim anticipatory bail by order dated 9/6/2023 has appeared before the investigating officer, and his statement has been recorded under section 161 of the Code of Criminal Procedure, 1973. I have perused the case diary. As the petitioner has complied with the orders of this court and has cooperated in the investigation, his custodial detention does not appear to be necessary if he continues to cooperate in the investigation. Hence, the interim anticipatory bail granted to the petitioner, namely Muhammad Rubul Ali, by order dated 9/6/2023, is hereby made absolute with condition number 2, 3, and 4 attached to the said order remaining intact. With above observation, this anticipatory bail application is disposed of. Send back the case.
Yes. If I, my lord, we have not received the case diary, my lord, he is on interim, my lord. Petitioner is on interim.
Heard Mr.
N.
N. Bormon, learned counsel for the petitioner. Also heard Mr. B. Sharma, an additional public prosecutor, who prays for some more time for producing case diary. The prayer is allowed. Let this case be listed again on
6/12.
6/12 for case diary. In the meanwhile, the interim order shall continue.
Artistic also, my lord, same prayer, my lord. We have not received the case diary today, my lord. Kindly have a little accommodation, my lord.
Heard Miss
B. Bora.
B. Bora, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this matter be listed on
6/12.
6/12.
Six, my senior will not be there, madam, on any other.
Then 7, my lord.
7 or 8.
8.
8/12. The interim order shall continue till next day.
37.
For 38 application lordship, petitioner is on interim lordship, and as per my instruction, it is he appeared before the investigating officer.
Yes, diary received, my lord. His statement recorded.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. P.B. Gogoi, learned additional public prosecutor, who has produced the case diary of Moirabari PS case number 137/2023 and has submitted that in pursuant to the directions of this court by order dated 9/8/2023, the petitioner has appeared before the investigating officer and his statement under section 161 CRPC has also been recorded. Stop. Considering the fact that the petitioner has cooperated in the investigation, the interim anticipatory bail granted to the present petitioner by order dated 9/8/2023 is hereby made absolute. With above observation, this anticipatory bail application is disposed of. Thank you.
Obliged.
Here, my lord, with all respect, my lord, relationship since 2008, interim was granted, and my lord, today it has come up before all. FIR, my lord, with all respect, page 11, apparent on face of the record, my lord, Major Lady, and my statement has been recorded.
Yes, my lord, his statement recorded.
Heard Mr. B.K. Mahajan, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail by order dated 31/8/2023, and in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in investigation. On the other hand, learned additional public prosecutor has produced the case diary of Gitanagar PS case number 169/2023 and has submitted that the petitioner has appeared before the investigating officer and his statement under section 161 CRPC has also been recorded. Stop. It appears that the petitioner has complied with the directions of this court and has cooperated in the investigation. Hence, the interim anticipatory bail granted to the present petitioner by order dated 31/8/2023 is hereby made absolute.
Highly obliged, obliged.
This anticipatory bail application is hereby disposed of.
40.
Yes, I checked, submitted, my lord.
Okay, submitted.
Appear before the trial court.
Maybe consider my lord, because it is a false case, my. Only one per eye. The lordship may be see to.
Heard Mr.
SR Borgulia.
Heard Mr. H.
SR Borgulia.
S.R. Bormia, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, the charge sheet has been laid against the present petitioner. In view of laying of the charge sheet, this anticipatory bail application is disposed of with an observation that the petitioner may approach the trial court and may seek relief before the learned trial court, if so advised.
That may be considered because it's a false case. Yeah, that may be
Before
considered
trial.
as per law.
If he will approach, my lord, that he consider as per merit of the case, my lord, not direction from.
Yes, maybe, yeah. As per merit.
It will otherwise also be. Yes.
Yes, diary is
Under section 438, the application under section Tamil case 209, 2003, 2050, under section 454A, 354D, 379, 8, 76, sorry, 506, IPC. My lord, my humble submission is that the allegation of the victim is that his father-in-law used healthy liquid and
interim আছে না? নাই।
to bed work. But the 376 is not applicable, my lord, because there is no ingredient of rape. So, my lord, my humble submission is that the dispute between these two, family dispute, he tried to live separately. Therefore, the 5 years allegation made against us his father-in-law. So, may kindly be
Yes, Mr.
Yeah,
Gogoi.
164 statement of victim, my lord. He touched her private part, my lord. That is.
My lord, my humble submission is during the place of occurrence, it is after a long period, she did not inform her husband and other family members. Therefore, my lord, it is suspectable.
Flag the 164 statement. Flag the.
Not readable openly, so I pass it.
Who is the accused?
Father-in-law.
This is not a case for grant of anticipatory. Mr.
May kindly be better to appear before the court.
You want to withdraw it?
No, sir. May kindly be direct him to appear before the court.
No, the case is pending investigation. So you have an option of withdrawing it or I will be dismissing it.
Withdraw কৰিব পাৰা তুমি নহলে এটা হেম্পাৰ কৰিব তলবৰ Up to you.
Yes. Heard, Miss. What is your submission?
Yes, sir.
Heard, Mr. H.S. Sarkar, learned counsel for the petitioner. Also heard,
No,
Miss.
he is S Das, my lord. S Das. Second name.
Heard Mr. S. Das, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 438 of Code of Criminal Procedure, 1973, has been filed by the petitioner Paritosh Bishwas, who is apprehending his arrest in connection with Tamodpur PS case number 209/2023 under section 354A/354D/376/3506 of the Indian Penal Code. This I will dictate in chamber. Your prayer is rejected.
May I please your lordship. Lordship, this is a 438 bill application. Lordship, the FI is at page number 11. The allegation against me is this, that Lordship,
Page
11. FI is at page 11. The allegation against me is this, that I, along with my family members, my wife and my children, I had attacked the husband of the complainant and I have assaulted him. On the contrary, Lordship, the fact is something different. The complainant and the complainant's family and the petitioner's family, they are neighbors.
History has arrived.
Arrived, my lord.
Injury report.
Injury report is also here, my lord. This is my lord, simple injury with my lord, sharp weapon. 3-cut injury, my lord. Yes.
Lordship, annexure B, Lordship.
Perhaps 326, my lord, will not come. Because my lord, it is simple injury with sharp.
The other co-accused are already on bail, Lordship, at page 18 and page 21, Lordship, annexure B and annexure C. They are.
You are Sanjeev.
I am Sanjeev Islari, Lordship.
Who are on bail?
Vichitra Islari, Rambha Basumatari, and Sansuli Islari. They are already in bail.
Okay, but they are women.
They are women.
That may be a ground.
The fact is this, Your Honor, I don't deny that there was an altercation that day, and it happened as a matter of self-defense, Your Honor. Lordship.
Heard Mr.
P.P. Medhi.
P.P. Medhi, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Sanjeev Islari, who is apprehending his arrest in connection with Kokrajhar PS case number 319/2023 under section 448/326/307/34 of the Indian Penal Code. The gist of accusation in this case is that on 14/9/2023, one S. Marak had lodged an FIR before the officer in charge of Kokrajhar Police Station, inter alia, alleging that on 13/9/2023 at about 11 a.m., the FIR named accused persons, including the present petitioner, entered into the house of the first informant and assaulted the husband of the first informant, causing grievous causing injuries on the person of the husband of the first informant. Stop. What is your submission? This happened or not?
Lordship, on that fateful day, Lordship, there was an altercation between the family members of the complainant and the petitioner because the complainant's husband there was a complaint of teasing on my daughter and my daughter. So therefore, there was an altercation in Lordship, and in the ensuing altercation, there was a physical scuffling was there, Lordship, and this is the truth, Lordship.
Learned counsel for the petitioner has submitted that the allegations leveled against the petitioner in the FIR is not true. In fact, it is submitted that in fact on that day, the husband of the first informant had teased the daughter of the present petitioner, and due to that fact, there was an altercation between the husband of the petitioner and between the family members of the two families.
Lordship.
In which two families stop. It is further submitted by learned counsel for the petitioner that there are 4 named accused in the FIR, out of which other 3 named accused persons were already granted bail by which court?
Lordship, Session Judge, the Honorable Session Judge Kokrajhar.
By learned Sessions Judge Kokrajhar. On the other hand, learned additional public prosecutor has produced the case diary of Kokrajhar PS case number 319/2023 and has submitted that though there are incriminating material against the present petitioner, however, from the injury report, it appears that the injuries sustained by the victim are not grievous in nature. They are of simple nature caused by a sharp weapon. Stop. It also statement of the victims have been
Statement of the victims is there, my lord, and others, my lord, eyewitness is also there.
It is also submitted by learned counsel, learned additional public prosecutor that the investigating officer has recorded the statement of victim as well as other witnesses. So considering the fact, I have considered the submissions made by learned counsel for both the sides and have perused the case diary of the Kokrajhar PS case number 319/2023 as well as injury report of the victim. Stop. Considering the fact that the other named co-accused are already enlarged on bail, as well as considering the progress made in the investigation and the fact that the victim has sustained simple injuries, this court is of considered opinion that custodial detention of the present petitioner may not be necessary if he cooperates with the investigating officer in the investigation. Stop. In view of above discussion, in view of above, the petitioner Sanjeev Islari is hereby directed to appear before the investigating officer of Kokrajhar PS case number 319/23 within 10 days from the date of this order and cooperate in the investigation. So if he does so within the stipulated period of time, in the event of his arrest in connection with Kokrajhar PS case number 319/23, the above named petitioner shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. This condition number 1 and 2.
My lord, kindly omit the statement of my lord victim. Victim statement is not here, my lord. Informant statement, my lord, other eyewitness statement is here, my lord.
Victim
There-
statement to continue.
Deeply obliged, Lord.
Okay, item number 57 is BA, okay. Two women behind the bar, okay. They are in both matter related to lotte same city.
Which should we take first?
But it's BA first. Item number 57.
Yes.
As on today, they are in custody for 36 days. FIR lotte will find
36.
Lot. Page 9 year lotte will find the FIR. Here what happened, Lotte? The petitioner number 1 is the daughter of
Page
petitioner
9
number
is the FIR.
FIR. And here in page 9, your Lotte will find accused number 1, Dipjyoti Das, he is the husband of the deceased. And that accused number 1 is brother of petitioner number 1 and son of petitioner number 2. And from
Accused
the
number 1 is the husband of the deceased.
yes, he is not before your Lord. He is already arrested as per my instruction.
Okay. And who are you?
I am petitioner number 1 is the sister of that accused number 1.
Not named accused.
Name, Lord.
Name.
All the family
Number
members are
5.
named.
Number 5.
Number 5.
Okay.
And number 3, Sarudas. Sarudas is mother. Mother of the accused number 1.
In this bail application, the petitioners are Bornali and
Bornali
Saru.
and Sarudas.
Both are women.
Both are.
Okay.
They are behind bars.
Yes.
And Lotte will find page 9 FIR itself says that Dipjyoti and the deceased got married by eloping Lotte. And within Lordship that 4 months, there was some dispute between them and she committed suicide. And they were, and there was no demand from the accused.
No, wait. She committed suicide.
She committed suicide. As per my instruction, which is subject to what my learned friend says. FIR also says he was found hanging, Lotte.
But the allegation is that you killed her.
Yes, my lord. It is there.
That medical report will prove that.
My lord, one thing, my lord, we have received, my lord, the postmortem report. My lord. Postmortem report is not inclusive, my lord, that it is further sent to my lord forensic laboratory or my lord chemical and my lord toxicological analysis. That my lord report is not received together. And otherwise, my lord, materials is there, my lord, the neighbor statement is there, my lord. The state, my lord, there are occasional quarrel between the family members and the deceased, my lord. So, my lord, at this stage, my lord, it is difficult to decide whether it is, my lord, suicide or, my lord, murder, my lord. And today is, my lord, 36 days, and it is, my lord, 90 days of next month.
If they stand for FSL report, also by keeping them in custody, that will mean no way.
My lord, no, my lord, it is only 36 days today.
So they are not proved guilty yet, Lord. If they are proved guilty yet, they can be for independent for life sentence. They can be kept. But what will
Now what materials are there apart from suspicion?
Apart from, my lord, apart from that, my lord.
Now the first, what I understand that first informant has suspected
Yes.
that the victim might have been killed.
Yes.
Apart from that suspicion, what other material?
My lord, one thing, my lord, I am taking it before your lordship, my lord, the postmortem report, my lord. There is no external link. That is also there.
But this
That's why
signature mark is there.
That is there. That is there. But my lord, that is why, my lord, it is doubt is there, my lord, some toxical that may be, my lord, served upon the.
No, any seizure, anything is.
No, my lord, that is. And my lord, from the statement, my lord, the lordship will find, my lord. That
And other symptoms of death by poison.
No, my lord.
There are other symptoms of.
No. At present, my lord.
So
it is same.
it is only suspected that
Yes, and my lord, if there is something, my lord, then FSL will, my lord, certainly reveal.
but for mere suspicion, whether they can be detained.
No, my lord, today is 36 days, my lord. At least, my lord, some, we can.
No, I want to understand
My lord.
what you will achieve by their detention.
Oh, my lord, if my lord, something positive, my lord, in the FSL report, with the FSL report will prove everything, my lord. If there is some toxical substances served upon her, my lord, that will come in the FSL, my lord. And if there is, my lord, no, then, my lord, at present, my lord, this is my submission, my lord.
And on last occasion also, they made that submission
Yes,
also,
my
and
lord,
therefore
yes.
short date was given.
Yes,
Lordship.
yes.
Just considering the petitioners both are ladies, women,
That is
Lordship,
true.
and they are already in custody for 36 days.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Otherwise, anybody.
Yes.
The
See.
statement is that she was.
Yes. Occasionally, my lord, quarrel with my lord, their daughter-in-law, my lord, with a family member.
But that quarrel Lordship probably will not attract us even 304B also, because that quarrel has to be in connection with dowry demand, the torture.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioners Bornali Das and Saru Das, alias Saru Bala Das, who are detained behind the bar since 13/10/2023 in connection with Hajo PS case number 614/23 under section 120B/498A/302 of the Indian Penal Code. The gist of accusation against the present petitioners is that on 12/10/2023, one Mitu Das had lodged an FIR before the officer in charge of Hajo police station, inter alia, alleging that the sister of the first informant, namely Manisha Das, eloped with the accused number one named in the FIR, namely Deep Jyoti Das, and were leading a marital life thereafter. However, it is alleged in the FIR that after that she was subjected to torture, subjected to physical and mental torture. It is further alleged in the FIR that on 12/10/2023, the accused persons named in the FIR had killed the sister of the first informant and have tried to give it a color of suicide. Stop. Learned counsel for the petitioner has submitted that both the petitioners are women, and petitioner number 5 is the petitioner number 4, namely Sarudas, is the mother-in-law, sister.
Petitioner number 2 is the mother of accused number 1 and
Is
mother-in-law.
the mother-in-law of the deceased, and petitioner number 1 is the sister-in-law of the deceased, and petitioner number 2 is the mother-in-law of the deceased. And it is further submitted that the allegations leveled against the present petitioner in the FIR is not true. It is also submitted by the learned counsel for the petitioners that in the meanwhile, the husband of the deceased namely Deepjyoti Das, has already been arrested. It is also submitted that there was some matrimonial dispute between the husband and wife, due to which the deceased had committed suicide. And the petitioners are no way involved in the death of the death of the Manisha Das. Stop. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the present petitioners on the ground that the vehemently oppose the grant of bail to the present petitioner on the ground that though the post-mortem report examination is available in the case diary, however, it is found in the post-mortem report that cause of death could not be what is the observation in the post?
Observation, my lord. Opinion regarding the cause of death is kept pending till the receipt of the chemical and toxicological examination report from the Director of Forensic Science and Laboratory, Kailipara plant. This is my opinion.
The cause of death of the deceased, no opinion has yet been given by the doctors who examined who conducted the post-mortem examination report.
Well,
it is also submitted by learned additional public prosecutor that it is suspected that the petitioner might have been, that the disease might have been administered. On what basis this suspicion is?
my lord, my lord, not there, my lord, but their quarrel part is
administered some poison, and which can be ascertained, which may be ascertained only after the receipt of FSL report. That ligature mark was found.
Yes, my lord, the fast, very fast part then on this is my previous specimen.
That she might have been administered poison. This is your submission.
My lord, because my lord,
but there is no witness has.
Yes, my lord. Regarding death, my lord, no witness.
There is nothing on the basis of which you are making this submission.
Yes. And my lord, that Quarrel part is there.
What was the last one? Which may be found, cause of which may be verified only after receipt of episode. I have considered the submissions made by learned counsel for the both sides and have perused the materials in the case diary, including the post-mortem examination report of the deceased. It appears that though the final opinion of the final opinion as regards cause of death has been kept pending till the receipt of the chemical and toxicological examination report. However, at this stage, it appears that where is the ligature?
Yeah, my lord, the opinion, my lord, then previous page, my lord. Before opinion, my lord. That's a ligature. Non-content.
Last word. That the victim, that the deceased appeared, that the ligature marks were found on the neck of the deceased, and she was found hanging when her dead body was recovered. It further appears from the case diary that investigating officer has recorded the statement of witnesses who are neighbors of the present petitioner, and they have stated before the investigating officer that there used to be occasional quarrel between the family members of the petitioners as well as the deceased. Nothing apart from this is available in the case record at this stage, in the case diary at this stage. And therefore, it appears that at this stage, apart from suspicion, there is nothing else against the present petitioners to justify their further detention for the sake of further investigation, for the sake of fair investigation of this case, if they otherwise cooperate in the investigation. In view of above, it also appears that the submissions made by learned counsel for the learned additional public prosecutor that the petitioner might have been administered poison does not find any support from any of the witnesses whose statement has been recorded by the investigating officer. In view of above, the above named petitioners are hereby allowed to go on bail of rupees 30,000 each with one surety of like amount subject to the satisfaction of
Judicial Magistrate First Class Hajo Kamru.
Judicial Magistrate First Class Hajo Kamru with following conditions. That both the above named petitioners shall cooperate in the investigation and shall appear before the investigating officer as and when so required by the investigating officer for the sake of fair completion of the investigation of the case. That both the above named petitioners shall not directly or indirectly make any inducement, threat, or promise to any person who may be acquainted with the facts of this case so as to dissuade such person from disclosing such facts to the investigating officer. With above observation, this bail application is hereby disposed of. Send back the case.
Next item, that is anticipatory bail for father who is aged about 63 years and brother of the husband.
Against them, apart from quarrel,
My lord, my lord, from the statement of neighbors, my lord, this is with family members, that is specifically, my lord, mentioned.
heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Romain Das and Pankaj Das, who are apprehending their arrest in connection with Hajo PS case number 614/2023 under section 120B/498A/302 of the Indian Penal Code. Acquisition from the advocate, same acquisition. Learned counsel for the petitioner has submitted that the petitioner number 1 is aged about 63 years and who is the father-in-law of the deceased and is in no way connected with the offense alleged in the affair. As regards petitioner number 2 is concerned, it is submitted that he is the brother-in-law of the deceased and he is also no way connected with the offense alleged against them in the affair. It is further submitted that the main accused, that is the, what is the name of the husband?
Deepjyoti Das.
Deepjyoti Das has already been arrested and is detained behind the bar. It is further submitted by learned counsel for the petitioner that the petitioners are ready to cooperate with the investigating officer in completion of the investigation. On the other hand, learned additional public prosecutor has submitted that same submission from the other earlier case. Same submission is same. Reasoning same. In view of above, this court is of considered opinion that custodial detention of the above named accused persons does not appear to be necessary if they cooperate in the investigation with the investigating officer. Hence, both the above named accused persons are hereby directed to appear before the investigating officer of Hajo PS case number 614/2023 and cooperate in investigation. So if they do so within the stipulated cooperate in investigation, they shall appear within 10 days. Within 10 days of the date of this order and cooperate in. Stop. If they do so within the stipulated period of time, both the above named stipulated period of time, comma, in the event of their arrest in connection with Hajo PS case number 614/23, they shall be allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition earlier confirmed. With above observation, this bail anticipatory bail application is thereby disposed of. Send back the case type.
Obliged.
His lordship, for a fiction. Challenge the FIR, my lord. FIR is page 33, my lord. Here, this petitioner is a grade 4 employee. And the allegation is that some excess amount is transferred from the accounts of the Treasury officer Hojai to a retired junior accounts officer. The pension amount is to 25,509. But 3 months may.
You have, Mr. Sharma, are you ready?
My lord,
Because on last occasion, the additional PP sought time for seeking necessary instructions.
my lord, at present, I have no instruction. my lord. Yes, clear.
Informant already submitted their affidavit in opposition. And
Who is for the informant?
my lord, this is a Treasury officer in charge. He was in charge Treasury. He has filed of the instruction of the Deputy Commissioner. And in his affidavit, he says that Annexer D page 30, that is on that letter, there is an inquiry on based on that inquiry, he has lost an FIR.
Today, my lord, he is not appearing.
On page 30, he mentioned about 5/8/2022 letter. 21 letter. That is the letter issued by Treasury officer to the Mintu Das. What happened, my lord? Mintu Das is no way connected. Only his connection is there. A amount
No,
system.
who is appearing for respondent number? No, before we proceed, we have to be sure that we can.
What is it? M. Separs.
Last 1 year, this thing. Almost.
Much late. Huh? It's what I get. Okay. Affidavit detail. What's on the mind?
What is to be done?
Lord, because my lord, the respondent 2 also not appearing today, my lord.
Affidavit is there.
Affidavit.
Simple commission 420 and 40649 cannot come because he is not custodian of this grade 4 temporary employee. And there is a lot of inconsistency. 67 days after this FIR has been lost in October, 5/8, it was detected that some excess amount is transferred. Not in his account.
Is there and my lord, status report is called for, my lord? Okay, if my lord,
Case diary is not there.
not there, my lord. Kindly have my lord. It is from Guwahati itself, my lord. It's on next week, my lord.
No, this is for quashing of the FIR. At least
Right.
case diary would be required.
Required, my lord. And my lord, that is called for by the
Last
previous order.
almost 10 months they have not. In bail application, it's moved and immediately they placed. Now it is not placed. My lord. Problem is that he is not getting bail. That is the problem.
You are behind the bar.
No. I am not, because anticipatory bail and previously this advocate moved, but it was rejected and to confession. So actually, in fact,
But for last 10 months.
10 months, man, this is pending. Last year it is filed. More than 10 months, man, almost.
Heard Mr.
MJ Buru.
MJ Burwa, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional public prosecutor, who submits that what is your submission? You are not ready.
My lord, the last occasion, my
That-
lord, CD
that
and
the-
status report call
that-
from that is not received, my lord.
That though the case diary was called for by order dated 24/8/2023, however, same has not arrived. and seeks some more time for producing the case diary. None appears for respondent number 2. Let this case be listed again after. When can you produce?
My lord, 28 or 29? No? 29.
Listed again on 29th November, on which date the learned additional public prosecutor shall ensure the production of case diary or the status report in the case, in case the charge sheet has, if the charge sheet is already laid, the
Then-
status report of the. No, last line. Shall produce the case diary. Let this case be listed again
On my lord, 29/11.
Last chance, 1 year.
Item numbers 19 and 20.
May I please? The division is for passing of the FIR and consider the entire criminal proceeding lordship. And in this case, lordship.
We are taking up 19 or 20.
May lordship 19 may be taken first, lordship, because where in this case, lordship, the informant's wife is also an accused. And second one is the same wife filed a complaint case against the present petitioner, lordship. Next one, item 20.
Okay. 19 plus 1025.
Here in this case, lordship, there are 3 FIR, lordship. These 3 FIR, lordship, first FIR is page 35, lordship. Which in the said FIR, lordship, police has submitted a FIR, lordship. That was filed by the husband, lordship, the accused number 2, lordship, in the FIR which I challenged. Translated copy, sorry.
Which FIR have you checked?
First FIR, lordship, page 35, filed by the present informant, lordship. Annexure 4, lordship.
Yes.
May I read, lordship?
Yes.
I have given the type copy also, page 35 and 36 is the original copy. With due respect, I, Anisullah Islam Chaudhry, resident of Lakhirban, Part 2 of Hailakandi district, would like to state before you that on dated 29/9/2020 in the morning, my wife along with my son, namely so and so, aged about 2 years, went out by saying that they are visiting the house of the relatives, but it was late evening that they have not returned. And in this, we tried to contact the house of the relatives, but found that they visit the house of the relatives, but they left the place on time. Following which, we started searching for them, but was not finding any trace. However, in the late hours, miscreants, namely Nurul Huda Barbiya, Naveen Huda Barbiya, both son of so and so. Nurul Huda is the present petitioner, lordship. Late so and so, Jamil so and so, all residents of Kampat Dungur are
contacting me and told that they have the child in their custody, following which I followed whatever they said, but till now, I realized that they are misguiding me, and as such, they have kidnapped my child and wife, and finding no way other, I have filed the instant case. Lordship, that case was registered under section 366 and 34, Lordship. In the said case, Lordship, police has submitted a FR, and in the said case,
against this FIR,
164 statement made. I am coming, Lordship.
FR has been submitted in this case.
FR has been submitted. Then again, another FIR, Lordship. Just I am coming.
You are not challenging this FIR?
No. This FIR, just I am giving the sequences, Lordship. In the said case, Lordship, petitioner got his bail, Lordship.
Though the allegation of kidnapping was there, what happened thereafter?
Thereafter, Lordship, police, she appeared before the police and made 164 statement, Lordship. Page 47, Lordship. 47 and 48, Lordship, Annexure 7.
The wife?
Wife, Lordship.
Okay.
The deposition of the victim aged 25 years on oath, solemnly.
At which page you are?
Page 47, Lordship. 164 statement, Lordship.
Yes.
May I read, Lordship?
Yes.
The deposition of the victim aged about 25 years. Taken also on count. Name Jasmine Begum Lashkar. She is the wife as well as the accused in the present 14 years. She can at the age of 14 years she was got married. Lordship, here is very peculiar case. I was married to Anisul Islam Chaudhry aged about 14 years ago. My husband
11 years.
11 years. At the time of 11 years, she has got married, Lordship.
Okay.
My husband, that is the present informant, Lordship. Complaint. My husband tortured me mentally and physically since marriage. However, I tolerated the harassment and gave birth to 2 children, one 8-year-old son and one 3-year-old son. About 1 year ago, my husband pronounced talak. Lordship, page 48. Talak upon me. And since then, we are staying separately in his house. Lordship, got it, page 48.
Yeah.
It is a type of original I have already annexed, Lordship.
Jasmine Begum. Yes. Thereafter?
Lordship, but he was tried so and so, so and so. I met Nurullah so and so. We developed a friendship at about 4 months ago. Started love affairs. I told him about the atrocities of my husband. Insisted him to marry me. On my request, we eloped on 28/9/2020. Everything, she is a consenting party, Lordship, and she is saying that earlier marriage with the informant was, she pronounced talak, Lordship. He pronounced talak. I took my younger son and with me, but on the next day, my husband called me up and asked me to send the son. I sent my son to him, so and so. On 29/9/2020, we married in front of Kaji. We are staying in a lodge in Karimganj Road, Hailakandi, since our elopement. I do not want to go with Anisur Rahman, that is the present informant. That case, Lordship, which entire case is based on that 164 statement, Lordship. Then her husband again filed another FIR.
In this case, FR was
already subsequently fully submitted FIR. Then second FIR, page 23, which I now challenge for quashing of the said FIR, Lordship, page 23. Lordship.
Yeah.
Page 23 is now under challenge, Lordship. With due respect and humble submission, I, Anisul Islam Chaudhry, would like to state before you that on dated 30/9/2020, I had filed a case in the Hailakandi PS case number, that is which I already earlier mentioned, regarding the kidnapping of my wife and minor child, who was recovered by police, but was unable to find my wife, and accordingly today, after the recovery of my wife, she appeared before the court, Lordship, and make that statement, Lordship. There was no question of any elopement, Lordship, by the police, and produced her before the court along with some marriage documents. And from that, it come to my knowledge that the documents relating to marriage which were submitted in the court, that the accused number 1, name is Nurul Huda Borboya so and so, in connection with the so and so accused number 4 so and so, made a conspiracy and prepared a marriage affidavit and notary certificate declares so as to decidedly introduce a belief in my wife that she was lawfully married, accused number 1, so as to prohibit with the accused number 1, which is illegal and an offense punishable under the penal provisions of law. And also accused number 1 made a conspiracy, including my wife, to steal away a sum of rupees 1 lakh from my house, which I kept for some business purpose in the safe place in my house. But on searching, I realized today that it was not there, as I was busy in finding my wife. Moreover, during subsistence of our, namely accused number 2, Jasmine Begum Lashkar, she is the accused here, Lordship. Accused number 2, knowing that I am alive and have not given her any form of divorce, married accused number 1, living with him as a husband and wife is an illegal manner. Besides this, my wife was willfully deserted 2 minor children, one aged about 8 years and another aged of 2 years, causing them a huge mental trauma. Even in my younger child, who is just 2 years ago, was a victim of her cruelty, as left abandoned near Shifa Hospital, from where the police recovered my son. As such, I therefore request you kindly initiate a strain and proceedings of illegal cohabitation, bigamy, and theft under penal provisions of law, as under Section 75 of the Juvenile Justice Act. Name of the accused, Lordship. Number 1, Nurul Huda Barbuya, present petitioner, Lordship. Jasmine Begum Lashkar, she is the wife of the informant, Lordship. And then so and so. Police registered this case, so and so. Then in their state case, Lordship, petitioner got the bail in both the 2 cases, Lordship, all the cases. Then police submitted a charge sheet, page 25. Just original page 29. Operative portion, page 29, Lordship. Of the charge sheet, Lordship, type copy I have given, original is there, Lordship, page 29.
Yes.
May I read, Lordship?
Yes.
The prosecution story in the case in brief is that on 6/10/2020 at 8:15 p.m., complainant Anisul Islam Chaudhry, son of so and so lodged a written FIR at Hailakandi PS on 30/9/2020. Jasmine Begum Lashkar, so and so, wife of so and so, daughter of so and so, fled away from her husband's house with her minor child, namely Adnan so and so. After them, the accused Jasmine Begum Lashkar left her minor child at so and so hospital care near the Katlichor bus stand, abandons condition, and fled away with the accused Nurul Huda Borwiya, so and so, so and so. The accused persons prepared marriage documents and accused Nurul Huda Borwiya, accused persons, Lordship, prepared so and so documents and accused Nurul Huda Borwiya married the accused Jasmine Begum Lashkar, had started their conjugal life. Just within that, Lordship, I am saying till today, this accused number 2 is with the informant, Lordship. Now again, she returned back. In course of investigation of the case of Hailakandi PS case number 81402, the minor child of the complainant so and so was recovered. accused Jasmine Begum Lashkar and Nurul Huda Borbuya was arrested and released on bail as per court order. There is some exaggeration of facts. Moreover, in the course of investigation of the accused, so and so is not sent up for trial as evidence was found insufficient against them. They are not involved. During investigation, a prima facie case has been found well established under section 120B 494 IPC, read with section 75 was against arrested accused Jasmine Begum Lashkar and Nurul Huda Borbuya. So I beg to send them up to court for facing their trial under the aforesaid section of law. My respective submission. Then again, the medical report, page 53. Last portion, Lordship, of this page 53. May kindly peruse, Lordship. It is written by the doctor. Refused to
Yes.
that apart, Lordship, this accused number 2 also filed a petition in the said case before recording her statement under section 164, Lordship. Then Lordship, also in the next case, Lordship, I have referred this annexure. But before that, Lordship, she while returned back again to her husband, previous husband, that is the informant in the instant case, Lordship. Then again, she filed a case against the present petitioner, which is item 20. I have annexed also here that petition, page 56. Annexure 8, Lordship.
Jasmine lodged
Again a complaint case.
against you.
Against me, Lord.
When she returned back.
To her husband.
When?
That is just after 1 or 2 months or 3 months, perhaps. While he has stated everything, Lordship, that was filed only on. Yes, I am coming, Lordship. That was filed on 18/12/2020. Page, Lordship, page 5 copy, page 56 to Lordship, or up to original page 67. In the said case, also petitioner got the bail, and then police submitted a charge sheet also in that case, which I am covering all the item number 20 also here, Lordship. I am trying to cover up this. Page 78 is the second charge sheet, which is against which the wife filed a complaint petition against this present petitioner. Lordship, page 78, second charge sheet, in which the wife filed a complaint petition. That is page 70. 56 to 56 to 67, Lordship. Against which police also submitted charge sheet, page 78.
So there are two charge sheets against you.
Loss against me.
One filed by the
Husband,
husband,
that is complainant, husband of the second charge sheet.
what is his name?
Anisul,
One filed by the Anisul
Lordship.
and one filed by Jasmine.
Jasmine. And Anisil, which filed, Lordship, there also, Jasmine is also an accused.
Yes.
And I'm just coming page 78, second charge sheet, Lordship. That is item 20, just I'm covering also that. May I read, Lordship, page 78?
Yes.
Type copy it is, originally is there, Lordship. The prosecution story of the brief is that on 7/3/2021 at 6:15, the complainant Jasmine Loshkar, daughter of so-and-so, lodged a written FIR pro CGM court Hailakandi to the effect that there was a long love affairs. Lordship, kindly note that, Lordship. There was a long love affairs between the complainant and Nurul Huda Barbuya, son of so-and-so.
Yes.
In this regard, on 30/9/2020, complainant Anisul Islam Chaudhry, husband of complainant, lodged a written FIR against Nurul Huda Barbuya and others by Hailakandi PS case number 814 of 2020. In course of the above case, investigation of the case, victim Jasmine Begum Lashkar was recovered and her son was also recovered. After recovery of the victim Jasmine, she was medically examined and judicial magistrate under section 164 statement, which I referred earlier, Lordship, was recorded. Judicial statement copy of the said victim was with the CD, which she stated that, which it was typed wrong, Lordship, stated that after recording her judicial statement as per honorable court's order, that may go of her own choice. Accordingly, the victim Jasmine Begum Lashkar cohabited with accused Nurul Huda Barbuya. It was learned that confidential victim Jasmine Begum Lashkar again married accused Nurul Huda Barbuya. Then, Lordship, again on 6/10/2020, complainant Anisul Islam, that is which I referred first FIR, sorry, second FIR, which is now under challenge before this honorable court. Complainant Anisul Islam Chaudhry lodged a FIR against accused Nurul Huda Barbuya and his wife Jasmine Begum Lashkar, that is the present complainant, Lordship. Filed Hailakandi PS case number 845 of 2000, Hailakandi PS so-and-so, dated so-and-so, charge sheet number so-and-so. In course of investigation of the case, complainant cum victim medically examined at SK Rai Hospital and report also collected concerning a point that no mark of violence is seen. Complainant victim was sent to so-and-so for recording her judicial statement under section 160 CRPC, where she stated that in her judicial statement that the accused Nurul Huda Barbuya committed sexual intercourse with the complainant cum victim without her consent. Lordship, without her consent, while the victim was staying with the accused Nurul Huda Barbuya. Also, it was learned that the said accused cheated with the complainant cum so-and-so, his signature in the stamp paper and made marriage document. Moreover, it was confidentially learned that the local reputed person, kindly note that, Lordship, local reputed person that the complainant cum victim, Jasmine Begum Lashkar, lodged the FIR due to sufficient pressure of her husband, Anisul Islam Chaudhry, to harass the accused person. Lordship, kindly consider that aspect. Evidence was found insufficient against so-and-so, more exaggeration of fact. Moreover, in course of the case of the case, the accused Nobin Huda so-and-so, village so-and-so, all are is not sent up for their trial as evidence was found insufficient against them. They were not involved in this case. During investigation, a prima facie case has been found well established under section 420, 376 IPC against arrested Nurul Huda Barbuya, son of so-and-so. So I beg to send him up the court for facing his trial under the aforesaid section of law. my resolution submission, after considering 164 statement, she on her own will, she has done everything. And subsequently again, she returned back. Her husband, while filing the case, making her as an accused in the present item number 20, Lordship, then she filed this instant complaint case against the petitioner, Lordship.
Yes.
That apart, Lordship, in item 20, Lordship, same, I have already referred some allegations on that respect, Lordship. Second one is the regarding the complaint of the victim, complaint case of the victim, which I came before your Lordship for consideration of the Lordship. In the second case, page 62, one petition was filed by the victim, Lordship, before the learned court below, while in the first FIR kidnapping case, Lordship. Its original copy, certified copy is also there. Page 62, Lordship, Annexure 7. It is called Jimma of the victim, Lordship. She has filed her own petition, Lordship.
Yes.
May I read, Lordship, please?
Yes.
Page 62, Annexure 7. As per most of so the petitioner happens to be the victim of this case. The petitioner victim willfully gone to the house of the accused, her own statement, Lordship, with her free consent and will. That is Jasmine Begum, wife of the first case informant, Lordship. The accused Nurul Huda never kidnapped or withdraw the petitioner from her house. It is also necessary to mention that the petitioner already got talak about 1 year back from her earlier husband, who inhumanly mental and physical tortured the petitioner prior to talak. That finding no other alternative, petitioner bound to take shelter, petitioner bound to take shelter in the house of the accused, and both the petitioner and the accused, with intervention of the local elder as well as wisher, performed marriage on 2/6/2020. Now she is with her first husband, Lordship, now till date. Since then, petitioner resided with the accused as husband and wife. It is also necessary to highlight that there has been no force of or coercion regarding petitioner withdraw from the informant's house as well as recent marriage. Hence, it is very important to pass necessary order regarding personal Jimma of the petitioner. Under the circumstances, I am reading the type of original copy is next page, Lordship, page 64. Our signature is everything is there, Lordship. And she also filed under the circumstances, your honor would be pleased to consider the matter above facts, kindly may accept this petition, and after perusal same, allow the petitioner for the personal Jimma of the petitioner for the ends of justice and oblige, Lordship. There's a verification also there. Page 64 and 65 is the original petition, Lordship. In spite of that, Lordship, police is submitting the charge sheet against me, Lordship, being a petitioner. And now I am not disputing on that, Lordship, since she has returned back to her original past husband, Lordship, that is the informant. I am not going for any dispute, Lordship, just to relieve from this case because it's unnecessary harassment. And in her above petition statement, Lordship, which clearly clarify everything, what is there, Lordship. And I already referred the Lordship charge sheet also that she is intention, Lordship, her main intention to harass at the instance of her husband, Lordship, the informant of the first case, that is item number 19, Lordship, which police has mentioned. So at this stage, my respectful submission, both these two cases, Lordship, my respectful submission, this FIR as well as the further proceeding of, that is the charge sheet, may be quashed, Lordship, because otherwise it is nothing but an abuse of the process of the court. Ultimately, if the proceeding will continue, there will be a bleak chance of any conviction. I'll refer some of the judgment on that respect also. Apart from that, Lordship, since she is, I am not.
You are referring to some judgment to show that on what ground charge sheet may be quashed.
Lordship, I am coming, Lord. Any fact is necessary, Lordship, on that which I referred, Lordship. Any
No.
clear? And my landlord friend also filed his affidavit saying something on that also, Lordship. My responsible submission, since the entire proceeding, Lordship, and charge sheet in my pleadings also, I have taken FIR as well as charge sheet, Lordship. Both may be set aside and quashed, Lordship, because there are the certain circumstances which is not available in the instant case to continue, Lordship. Lordship, I'm coming just one by one and supplying the copy of that, Lordship, of the judgment also. First judgment I am referring, Lordship. It is a criminal appeal number 21217 of 2022. It is not reportable, Lordship, but some points are there, Lordship. I am applying the copy of that also. Lordship, in that judgment was decided, Lordship, on 10/8/2022, I think.
Which are the relevant paragraph?
Relevant paragraph, page 12, sorry, paragraph 12, Lordship. Next page, paragraph 5, middle portion, whether there is a strong possibility of conviction or a chances of conviction are remote or blank. On that, Lordship, immediately, Lordship, those cases were tried. Paragraph 13 also, Lordship, page 6. It can thus be seen that this court has clearly held that though the court would be slow in quashing the proceeding where heinous and serious offences are involved, comma, the High Court is not foreclosed from examining as to whether there exists material for incorporation of such an offence or as to whether there is a sufficient evidence which, if proved, could lead to proving the charge or for the offence of charge. The court has also taken into consideration as to whether the settlement, there was no settlement, Lordship, though earlier occasion Honorable Court was asked for that, Lordship. Settlement between the parties is going on, that I'm not. Paragraph 14, Lordship. The court has further held that it is also relevant to consider what is the stage of the proceeding. It has been observed that if an application is made at a belated stage where the evidence has been laid, here in this case, Lordship not yet started proceeding, Lordship. The matter is at the stage of argument or judgment. The court should be slow in action. However, if such an application is made at an initial stage before commencement of the trial, the said factor will weigh with the court in exercising its power. In both the cases, the charge sheet have been filed, the charges have been framed. Not, in our case, charges has not yet been framed. In supporting the procedure, even if the criminal trial is permitting to go ahead, it will be end in nothing else than an acquittal, Lordship. I'm coming on that, Lordship.
interim stay has been granted in this case, both the cases.
Lordship.
There is no interim.
No, Lordship, because bail was there. Honorable court, bail was there.
Then what is the stage?
Not yet. No summon has yet been issued.
Okay.
Not yet. As per my instructions so far, not yet. Nothing. Last in appeal is allowed, and the proceedings so and so arising out of FIR are quashed and set aside. We are grateful, so and so, so and so. Here in this case, Lordship, both the FIR was and the charge sheet was quashed, Lordship. We find no in any serious crime like rape, and the court should not normally exercise the power quashing of proceeding in the peculiar facts and circumstances of the present case. The order to give a customer saw that she is saved from her further agony of facing two criminal trials, one as a victim and one as an accused. Here in this case, Lordship, one is in accused and one is in the victim, Lordship. He has filed. She has filed, Lordship. Then, my lord, I am coming 2019 9 SCC.
So in this judgment, there are two things.
Lordship.
The judgment which you have now relaxed.
Lordship.
That there is no material for incorporation of such an offense.
Lordship.
And there is insufficient evidence. Court can look into it.
Lordship.
Only these.
Lordship. I am coming also that other point also, one by one, Lordship. 2019 9 SCC 608, Lordship. I'm supplying the copy of that also. Hey, so you wait. 2019 9 SCC 608, Lordship.
Yes.
Lordship, paragraphs 6 in the said judgment, paragraph 6, 7, and 8, Lordship. Just I am reading about my point of quashing, Lordship. Paragraph 7.
Yes.
No, sorry, Lordship. Paragraph 6 may also, some highlights are there, Lordship. I may read, Lordship. Section 482, paragraph 6, Lordship. Section 482 is an overriding section which saves the inherent powers of the court in advance to cause justice. Under Section 482, the inherent jurisdiction of the court can be exercised to give effect to an order under CRPC to prevent the abuse of the process of the court, number 1. And number 2. Number 3, the other was secure the ends of justice. The powers of the court under Section 482 are wide, and the court is vested with the significant amount of discretion to decide whether or not exercise them. The court should be guarded in the use of the external jurisdiction to quash an FIR or criminal proceeding, as it denies the prosecution the opportunity to establish its case through an investigation and evidence. These principles have been consistently followed and reiterated by the court in Indramohan Goswami versus State of Uttaranchal. This court observed that this court in a number of cases has laid down that the scope and ambit of the court's power under Section 482. Every high court has an inherent power to an ex judicial justity to do real and substantial justice for the administration of which alone it exists, or to prevent abuse of the process of the court. Inherent powers under Section 482 CRPC can be exercised, number 1, to give effect to an order under the code, to prevent abuse of the process of the court, to otherwise secure the ends of justice. Then in next, inherent powers under 482, though wide, have to be exercised sparingly, carefully, and with a great caution, and only when exercise is justified by the test specifically laid down in this section itself. Authority of the court exists for the advancement of justice. If any abuse of the process leading to injustice is brought to the notice of the court, Lordship, then the court would be justified to preventing injustice by invoking inherent powers in absence of a specific provision in the statute. My resource submission here is clear abuse of the process of the court, Lordship. One FIR filed in which FR was submitted, then subsequent FIR filed where accused victim is the accused. Then while the victim returned back to her husband, then again she filed. This is the police already mentioned that local people also exact things were told, Lordship. Then I'm coming, Lordship. Given the very natures of the cases come before the High Court, any strict test as to when the court extraordinary powers can be exercised is likely to tie the court in hand to face the future injustice. The court in a state of Haryana versus Bajanlal, this is the first Lordship base case, Lordship, I can say, conducted a detailed study of the situation where the court may exercise in extraordinary jurisdiction, laid down a list illustration example as to where quashing may be appropriate. It is not necessary to discuss all the examples, but a few bear relevance to present case. The court in Bajanlal, Lordship, this is noted in the quashing may be appropriate where number 102 paragraph 1, where the allegation made in the first information report or the complainant, even if they are taken at their face value, accepted their entirety, do not prima facie constitute an offense or make out a case against the accused. Lordship, then where the allegation in the first information report and other materials, if any, accompanying the FIR do not disclose a cognizable offense qualifying an investigation, justifying an investigation by police officers under section 156(1) of the code, except under an order of a magistrate permission. Where a criminal proceeding is manifestly attended with malafide, I am coming to that, Lordship. Where a criminal proceeding is manifestly attended with malafide and or where proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. Lordship, just I am referring the background, Lordship. Actually, both these informant as well as the present accused, they are doing some business. They are in Hylagan, and there was a dispute, Lordship. And subsequently, this part was developed, which she has admitted in her position. What she is a grown-up lady, Lordship. She have enough maturity, Lordship, is there having 2 children. Then, Lordship, in deciding whether the 482 the court does not adjudicate upon the veracity of the facility so and so. Then next, Lordship, in paragraph 8, subparagraph 13, it is clear that the quashing of Lordship.
We have to stop.
Lordship, sorry. Let it be parted, Lordship.
It has to be, because we have
taken enough
taken
time,
lot of
time, Lordship.
When will you, you will take how much more time?
Lordship, only judgment,
When can be?
Any subject, any day, subject to convenience of this honorable court, Lordship. Any day, I think my learned friend, how much I can know. No, I will just, on the 10-15.
Then on with Tuesday, hearing day.
Any hearing day, Lordship.
Gitanjali. Parted.
120. On 23rd or no, sorry. Any day subject to convenience, we have no problem, I think. Huh? Parted, no problem. No. I can finish the project.
Kali. On 23rd. Third, Mr. K. A. Majumdar. learned counsel for the petitioners. Also heard Mr. A.M. Bordwin. Heard Mr. K.M. Majumdar, learned counsel for the petitioner. Hearing remained inconclusive. Mr. A.M. Bordwin is also present. Let this matter be listed again on 2023 as a part of that.
Lordship, please.
Regarding leftover matter,
Lordship, please. Oh, sorry. Deep problem. Deep problem.
Hello, item 52 is also a part matter, who has agreed to the learned counsel with the respondent to aim for the petitioner. Can it be fixed on 12th of December?
we have to see the diary. In all leftover matters, due to paucity of time, this case could not be taken up for today. The dates will be given by the court master as per the convenience of the court as well as your convenience.
My lord,
Wherever there is a interim will.
my lord, I'm sorry to say, my lord, in item number 55, my lord, 3 times it was listed partly leftover, my lord, and the appeal, my lord. So only partly admitted. If the appeal is admitted, then notice will be go. So my lord, that matter Monday or 55, my lord.
Accommodate all of them.
Highly over. No.
এতিয়া ৰখি আছো।
সেইটো আমি নাজানো আহিব নহয় নহয় দৰকাৰ নাই বুলি মই ক'ব নোৱাৰো মেটাৰটো চালেহে গম পাম আহিব লাগে নিয়মমতে সেইটো আমাৰ নহয় সেইটো আমাৰ সেইটো sensitive matter.
নভেম্বরের কত মঙ্গলবারটা
Tuesday. Monday.
28 নিয়ে